application of letter lawsuit, item number 42 and 43. Was listed for 5 times, but never reached.
Item number?
42 and 43. But she has directed us to file a contempt case in this case. Demarcation. Regarding demarcation.
What are these matters?
Regarding demarcation of the case, Lordship. Regarding demarcation, the circle officer was directed to present to give the minutes of the demarcation. Lordship. He did not give the minutes till date, Lordship. So Lordship directed us to file a contempt case. We have filed a contempt case also, that is along with this IM also. Today it is come.
Take it up at two.
Lordship. Always.
Very pleased, Your Lordship. The item number 16 and 17. Second appeals. Perhaps the Lordship would like to take it up.
Right.
My friend says without, maybe in a connected matter, Your Lordship was there. Good luck.
You have need to mention for listing of what higher for particular campus settlement. Tomorrow, Lordship, it was
9th of May.
listing this matter, NSC appeal.
Right.
That will have the respondent by the way, find out. Order.
9th.
Please, Lord. I bet to mention item number 11, Lordship, it's become infrastructure. Matter become infrastructure.
Will you stay?
No, Lordship.
You stay.
Wanted to examine the position of 27 blood vis-a-vis the orders passed by the judge.
Your name?
MM Daman.
And Jaman, the council submits the instructions to the full. Nation. And screw.
One confirmation application. We are respondent, we have filed our objection. Any day.
Nation, why?
They filed one confirmation application against the order passed by the London Civil Judge Senior Division. Allowing our suit to be decided by civil court. There is a dispute whether it is to be decided by London or civil court.
They filed 115.
Or ship. So what IA was also there.
9th.
Okay. That is it. For listing math appeal, I am for respond the last listed or 4/12/20. They have to Nepal listed.
And B.
On 9.
Why?
For orders. Apply. Lordship. I go to pay for agenda matter item number 7, Lordship. Item number 7, Lordship. After the direction I have filed the additional appeal.
Who are you?
Lordship.
Who are you? Who are you? Why you are in the count? In that matter where I asked you not to appear. Remember? Then why you are appearing? Remember? I don't forget matters. Then why you are appearing in the gown? Are you not the respond number, the petition number 5? Then Then how are you appealing? Tell me. There was another person now, SK Das. Then where is he? Don't keep on making mistake. Your name is Mr. Diganta Burman. Then why you are making the mistake? Every time.
One week lordship.
1 week, I am not going to hear you. Either you say that you are not wearing the gown, then you make submission, then it is okay. But you have no business to appear for 1 to 4. Then
Maybe your lordship. Lordship, in item number 15, the Guwahati High Court has filed their affidavit on Friday. So I need 2 weeks time to file my reply. Yes, Dr. Madam, I am appearing for a private person. I have also not received a copy of the affidavit, madam. I may also be allowed to file my affidavit.
mention when the matter reaches. I don't grant adjournment at this.
Highly honored. Sir, please, lordship, also I beg to mention for listing of a second appeal, my lord, on madam, Friday, my lord, Friday.
Why?
There is an urgency, madam.
What is the urgency?
Madam, we are filing, second appeal on 11th of 4th, madam, listed, my lord.
Huh?
We are filing the second appeal on 11th of April, listed.
Want it under order 41-11. You want it under order 41
Motion for motion, for motion, my lord.
Huh?
For motion, my lord.
Motion. Very well. We'll have it not on the year, we'll have it on 14. 9.
What's the question?
Lordship, to the consent of other party, opposite party, I beg to mention item.
Wait, slow. Tell me.
To the consent of the opposite party, I beg to mention item number 34.
7.
34, item number 34.
34. Bye. Transfer petition. Who wants to go where?
The
You
petitioner,
are a petitioner.
Yes.
Bye.
Lordship,
You have asked for a transfer. Which will allow it.
senior counsel is not well.
Yeah?
Senior counsel is.
You do it. Don't ask for adjournment. This type of matters. Only. Yes, Mr. A. Moving.
Item 22, lordship. The appellant, lordship, but the appellant has taken another 5 from me.
Huh?
Be allowed to go.
You can't withdraw from this case like this. You have to file an affidavit that nothing, you are no longer there.
If then I may be allowed.
There are so many other councils out there, AM, you are not there itself.
Yeah, the item 22.
Yes, you are there. You want to withdraw
Lordship.
because
The
wakalat naman.
petitioner has taken over the file and in the meantime,
Don't believe so when the matter comes.
lordship.
Petitioner having
Well, I
taken
may be
away,
allowed
and
sometime
if the
to relevant.
petitioner does not appear, then we dismiss for default. Don't worry. Petitioner has taken away, don't appear. We dismiss for default.
For motion item 1,
Yes, you want to go from where to where?
From Guwahati to Silchar, my lord.
Huh?
Guwahati to Silchar, from family court, Guwahati to Silchar. But this petitioner already has filed a proceeding in the DPA, under the DPA, where the respondent herein appeared and contested, and an interim order was also passed, and he is appearing there. Thereafter, he filed this restitution of rights application.
Application for what?
Restitution of the legal rights at page 37.
Page 49.
Page 37.
Read that. Now, what is page 49?
49 is,
You want the transfer of this?
no, the case at page 37, I want transfer.
You have filed the divorce.
Yes,
What is-
yes,
You
yes.
have filed the divorce.
Divorce there, yes.
It's pending. It's sure.
And also I've, DB case also there. DB case I have filed first.
And this is an application for constitution of conjugal rights.
Yes. This is for harassing. There is nothing.
I'm not just making it. This on. 2nd of June 2025. Steps be taken upon the respondent by way of registered at 2 days. Steps by way of trustee. File an affidavit. It is an application filed under section 20 of the Code of Civil Procedure 1908 of the code, seeking transfer of the proceedings being FC civil case number 1585 of the 2024 pending before the Principal Judge Family Court, Kanpur Metro and Guwahati. On the ground that two other proceedings are presently pending before the Court of Principal Judge Family Court, Kachar at Silchar. Being FC civil case number 63 of the 2025, as well as, what is the DB case number?
Page 60.
DB case number?
Of 181 of 2023.
Public 2024,
23.
taking into account that there are various proceedings pending before the Principal Judge Family Court, Kachar, at Silchar, from the opinion of this court, it is a private facie opinion of this court that this matrimonial dispute ought to be required or required to be decided in one court. As much as there are, as much as in one, that view of the matter is the further proceedings of FC Civil number 1585 of 2024 pending before the Judge Family Court, Kamrup Metro and Guwahati till the next. 1585.
Yes.
Item two,
What is this? Landlord tenant?
Yes, sir. Yes, the lots.
Concurrent,
But there are some contradictions also. with that.
concurrent
Concurrent, and also some contradictions
on
also.
both counts. How long you have been there?
I was from 1977 onwards. The father,
So we just require another 2 years to remain to make it 50.
it's a business concept, but our case is that we are not default of rent. We paid the rent on time.
Huh?
We are not the default of rent.
But why does the court has found that you are a defaulter? Yes, give me a go. Tell me. What is the perversity in the findings?
Except in the connect course below. Both in the trial. As well the affidavit, the finding of purpose and the finding of different.
You telling me it is perverse, finding would not make it perverse. Tell me why.
The lordship in the trial court does.
Show me the perversity in the first appellate court's order on the finding of defaulter.
Your lordship can kindly reverse to page number 104, the appellate court, does that regarding issue number 3. The current appellate court held that the petitioner is defaulter of rent from
Within the, now, paragraph 26. Page 108.
the before that, if a lordship can come to page number 107, your lordship, from top. In light of these regulations, the burden lay on the defendant to prove that the rents were paid to spring. Pranab was one of the landlords. The defendant did not produce bank statements to prove that the rents from the month of September 2012.
Yes, what did you show? From September 2012 to July 2014, what did you show?
But the fact is that the checks which we have deposited to the landlord, were not returned to us till date. Even though the checks were not encashed, but the same were not returned to us till date. And the Latin trial court held.
What evidence did you give? From September 2012 to July 2014?
We deposited the checks with the, for the purpose of tendering the rent.
Huh?
We submitted the checks for the purpose of tendering the rent. to One of the landlords, lordship from the month September 2012 to July 2014. Those checks were not returned to us till date.
Where those checks deposited? So you must have shown it that it has gone from your account. It will be apparent if your check has been deposited. Did you show that?
Evidence required that,
Not necessary. Don't worry. I am not going to look into those things. Evidence, I don't even look into all this.
but the Ladakh trial court held that
How many months do you require to vacate?
your lordship says that this is a business concern and the business was running from the year 1977. I know, and
Does it become, does it make him the owner?
No, your lordship, that is the,
That I said.
this some bit required.
Hmm?
The records will call for. The records will call for.
Mr. Counsel, you are appearing for the first time, eh?
And then I can substantiate it. Then I can substantiate it.
When?
If the records are called for.
Huh?
If the records are called for, then I can substantiate.
Then you can vacate.
I can substantiate.
Show me. Forget about this. Second appeal, I don't call for records. I don't frame a consumer. So what do you think about this? You are on TV?
I'm okay with.
Tell me.
I'm okay with.
Huh?
I'm okay with.
What do you want? Should I dismiss on the first day?
As your lordship pleases, I must say like that, as your lordship pleases, because no doubt he is a constant defaulter, rank defaulter, my lord, and that has
He is a defaulter, not only defaulter, but a rank defaulter, my lord. Months together, the rents are not paid. That is the admission part, my lord. But today, if he needs any time to substantiate before your lordship, I won't object to them.
But I am not going to issue this type of matter notice in the.
Of course, my lord. But I am very much here. I filed the table. Yes.
You need one more date for preparing. That is the only good thing I can do, because today is a Monday. Otherwise, no. For preparing. Or for issuing even a notice. And take instructions when you are vacating. These are the two things you will.
At least 2 weeks time.
Don't please. Go ahead. You filing. I'm here till June. Doesn't help you. This bench. At last. Let us finish it.
Can come one more time. So that I can satisfy. I'll try it.
Well, for ninth. Ninth is the last day.
I,
We have difficulty. Well, we solve your difficulty. What is your name?
AM
Mr. M. Datta, the learned counsel appearing on behalf of the petitioner, and Mr. A. Sattar, the learned counsel appearing on behalf of the respondents. We dispose it of.
6 months time to
This
answer.
is an application filed, it's enough. This is an application filed under section 115 of the Code of Civil Procedure 1908, read with section 151 of the said code. This is an application filed under section 115 of the Code of Civil 1908, for short the code. Read with section 151, challenging the judgment and decree dated 30/8/2024, passed by the learned court of the Civil Judge Senior Division, Kamrup Metro at Guwahati, by which the judgment and decree dated 22/3/2022, passed by the court, learned court of the Munsif number 2, Kamrup at Guwahati, in title suit number 242/2014, was upheld, was affirmed. Either civil judge number 2 clear, learned first appellate court, or with learned private. Push. Paragraph number. Yes, sir. Right. Sure. You can see. The respondent number 1 and 2 hearing as plaintiffs had instituted the suit being title suit number 242/2014. Against the defendant before the court of the learned Munsif number 1, Kamrup Metro at Guwahati. The learned hereinafter referred to as the learned trial court. Against the petitioner herein seeking ejectment and recovery of khas possession of the suit premises. The case of the plaintiffs is that the plaintiffs, along with the two others, namely one Pranab Kumar Saha and Sri Sudip Saha, by dint of purchase by the registered sale deed number 3873/11, dated 9/5/2011, became the absolute owner and possessor of a plot of land at measuring 17 lectures covered by dark number 3297 old oblique 269 new of KP Patan number 6 old oblique 86 new of village Sohor Guwahati part, fifth part of Moza, Ulubari, Guwahati, along with an old RCC building. Custom. The said property have been duly described in the Schedule A to the claim. Custom. The defendant hearing, the petitioner hearing who was defended was a monthly tenant of the vendors of the plaintiffs in respect of a shop room described in Schedule B to the plaintiff. Custom. And the vendors of the plaintiff by the letter dated 6/6/2011 had duly informed the defendant about the intention to sell the property described in Schedule A to the plaintiffs and to others. The defendant, on receipt of the said communication, informed to the vendors of the, to one of the vendors of the plaintiffs, one Mr. K.C. Sirkar, by the communication dated 10/6/2011, that the about his intention to pay the rents to the plaintiffs. And to whom the said rent is required to be paid. Whose- It is further mentioned that the defendant upon being communicated sometime in the month of June 2011, he started paying the rent to the plaintiff number one from the month of June 2011 in the first week of every succeeding English calendar month at the rate of rupees 2450 per month. And in that regard, he attached to the tenancy this payment of the rent continued. In the meanwhile, the other two purchasers of the Schedule A property, namely Sri Pranab Kumar Saha and Sri Sudeep Saha, in the year 2014, decided to sell their share of the Schedule A property in favor of the plaintiffs number 1 and 2. And as such, in furtherance to their decision, they executed a registered deed of sale bearing deed number 2816 dated 15/3/2014 in favor of the plaintiff number 1 and 2. And since then, the plaintiffs have become the absolute owner of the Schedule A property. It is the further case of the plaintiffs that the defendant paid the rent regularly to the plaintiff number 1 up to the month of August 2012. But all of a sudden, without assigning any reasons, the defendant stopped making payment of the rent from the month of September 2012. It is the further allegation in the claim that the defendant, instead of making payment, instead of paying the monthly rent to the plaintiff number 1 and or depositing the same in the court, kept silence for a period of 15 months and never tendered the rent to the plaintiff number 1. But thereafter wrote another letter to Sri Pranab Saha on 7/12/2013 and thereafter on 6/1/2014, alleging inter alia that the rents are not received and hence the rents from the month of November 2013 by way of check number 224607 and the rent for the month of December 2013 by way of check number 224616 dated 4/1/2013 were enclosed. And if the same is not received, then the defendant had no alternative but to deposit in the court. It has also been alleged that for the period from 1/9/2012 to 31/8/2014, the defendant did not pay the rent, and as such, there was an arrear of rupees 58,800. So it is not on bona fide requirement.
Yes, that is also.
Where? Which paragraph?
Definitely was dismissed. On appeal, the benefit, the benefit requirement was rejected.
Obviously, there's nothing on bona fide. On the ground of, therefore, defaulter in payment of rent, the suit was filed by the plaintiffs seeking ejectment of the plaintiff, defendant, and for recovery of area rent. The defendant filed a written statement raising various preliminary issues as regards the maintainability of the said proceedings. It was mentioned in paragraph number 10 of the said written statement that the suit premises was taken on rent by late Dilip Kumar Sanyal, the father of the defendant, on rent from Sri Kritish Chandra Sirkar. And the bookshop under the name and style of Assam Publishing Company therein was established. It was denied in the said paragraph that the Schedule A property was purchased by the plaintiffs and Sri Pranab Saha and Sudeep Saha with prior intimation to the defendant. It was also mentioned that after the sale of the Schedule A property by the registered date dated 12/5/2011, the said vendor by letter dated 6/6/2000, the vendor of the plaintiffs by letter dated 6/6/2011 had informed the defendant about the sale that the entire land and the building has been sold to the plaintiffs and Mr. Pranab Saha and Mr. Sudeep Saha, and hence the defendant was directed to pay the monthly house rent to the said persons or their authorized representatives for the month of May 2011. It was also mentioned that the defendant by letter dated 10/6/2011 wrote a letter to the plaintiff number one that the defendant had atoned to the plaintiff number one, as well as the three other joint owners of the property, namely the plaintiff number two and Mr. Pranab Saha and Sudeep Saha as his landlords, and asked the plaintiff number one to inform him as to whom should the defendant tender the monthly rent as the rented premises was sold to four persons. At paragraph number 12 of the written statement, the defendant denied the statement made in paragraph number 4 of the claim to the effect that the defendant started making payment of the rent from the month of June 2011 onwards. To the plaintiff number one. It was stated that the defendant had atoned to all the four new purchasers as the new owners of the rented premises and had recognized each of them as a landlord. In paragraph number 15 of the written statement, it was stated that as the plaintiffs have refused to accept the rent from the month of September 2012, in spite of the rent was duly tendered by the defendant to the plaintiff number one, the defendant by letter dated 14/10/2012 paid the rent for the month of September 2012, which Sri Pranab Saha, who was also a landlord by the check number 857994. And thereafter, the rent for the period from October 2012 to July 2014 were regularly paid by the defendant to Sri Pranab Saha. The defendant further gave details as to how the rents were paid for the period from October 2012 to July 2014 and by the respective check and the check numbers. It was also mentioned that although the rent for the month of August 2014 was tendered to Sri Pranab Saha by the defendants by letter dated 3/9/2014, but the same was returned back to the defendant as Sri Pranab Saha had refused to accept the rent. As such, the defendant was left with no other option but to deposit the rent from the month of August 2014 to the court of the Munsif as per the provisions of the Assam Urban Area Rent Control Act 1972, for short, the Act of 1972. On the basis of the above, the defendant therefore claimed that that the defendant was not a defaulter in payment of the rent. On the basis of the pleadings, the learned trial court framed as many as 6 issues initially. And subsequently, an additional issue was framed. The issues, as well as the additional issues, are reproduced herein under page 54. On behalf of the plaintiff number one examined himself as his witness. And exhibited various checks, various documents, which were marked as Exhibit 1 to Exhibit 11. On behalf of the defendant himself adduced evidence as DW1, examined himself as the DW1, and exhibited various documents as from Exhibit A to Exhibit AD. So Sattar, he did not exhibit his account statement.
His account statement, my lord, I never had.
No, he
He did not exhibit any account statement.
did not examine his exhibit the account statement. Then how will you know? How will one know that the checks were at all honored?
Checks you are issuing, my lord, to Parnab Saha and Sudipta Saha. So they never encashed it. And
Huh.
by that time, they had already sold their share of the property.
No. They sold in 2014. But these checks were for the period from November, October 2012 to this to July 2014. These were.
Yes.
But whether these checks were at all encashed,
That was not encashed by us.
it is relevant to take note of.
My lord, my lord, the additional issue which is framed is with regard to the bona fide requirement, for which, my lord, in the plain, paragraph number 14 speaks of that. Paragraph 14. At page number 29. 29,
No. This type of, yeah. Finish.
yes.
However, it is relevant at this stage to observe from the exhibited documents, from the documents so exhibited by the plaintiff, by the defendant, that though the various checks, the letter, though the various letters by which checks were sent to one Pranab Saha were exhibited, but there was no document exhibit, no bank statement exhibited to show that these checks at all were encashed. The learned trial court, by the judgment and decree dated 22nd of March 2022, decreed the suit in favor of the plaintiffs. While deciding the issue number 3, as to whether the defendant was a defaulter in payment of monthly rent from the month of September 2012 to the month of August 2014. The learned trial court came to a finding that the that there was no iota of evidence to indicate that from September 2012 to July 2014, Sri Pranab Saha refused to accept the rent. And as such, till July 2014, the defendant was not a defaulter, as he had paid the rent to Sri Pranab Saha as one of the landlords, being ignorant of the fact that Sri Pranab Saha had sold his share in the property in the month of March. The learned trial court, however, came to a finding that during cross-examination of the DW1, that is the defendant, he deposed that he paid the rent due in the month of August 2014 by Exhibit AD1, for which the challan was passed on 24/9/2014, and the amount was deposited in the bank on 7/10/2014, that is after a lapse of the due date. The learned trial court further came to a finding that in respect to the month of September 2014, the challan was passed from 28/10/2014, and the amount was deposited in the bank on 4/11/2014 by Exhibit AD2. The learned trial court further came to a finding that by Exhibit AD bracket 37, the rent for the month of September 2017 was deposited before the same had fallen due. And by Exhibit AD 51, the rent for the month of November 2018 was deposited on 19/1/2019, that is after the lapse of the due date. The learned trial court further, taking into account Section 5(1) of the Act of 1972, as well 5(1)(e) of the Act of 1972, therefore came to a opine that the defendant was a defaulter, as the rent was not paid for the months of September 2014 as well as September 2017 and November 2018, as per the provisions of Section 5(1)(e) of the Act of 1972. This court further finds it relevant to take note of that in respect to the issue pertaining to bona fide requirement of the plaintiff, the learned trial court, taking into account that the plaintiff, being the landlords, were the best judge as to how to use and utilize their own property for their own good, and the defendant was not in a position to raise any objection without any cogent reasons, concluded that the plaintiffs had bona fide required use for expansion of the existing business of bookstall. On the basis of the above, therefore, the learned trial court, by its judgment and decree, decreed that the judgment and decree that the defendant was liable to be evicted from the suit premises, including his men, materials, and the plaintiffs were entitled to get khas possession and vacant possession of the Schedule B premises, and further that the plaintiffs were entitled for recovery of rent, recovery of area rent for the months of November 2019 till recovery of the scheduled premises at a rate of rupees 2450 per month from the defendant. It is seen that the defendant being agreed preferred an appeal before the learned first appellate court, which was registered and numbered as title appeal number 10/2022. The learned trial court, first appellate court, in terms with order 41/31, duly considered the grounds of objection, recorded what was to be, what were the points for consideration, and thereupon affirmed the judgment and decree. Passed by the learned trial court by its judgment and order dated 30/8/2024. It is, however, very pertinent to take note of that the learned first appellate court while deciding the issue number 3, came to an opinion that the defendant came to an opinion that the defendant was not only a defaulter in payment of rent for the months of August 2014 and September 2014, but was also a defaulter in payment of rent from the month of September 2012 till August 2014. On the issue pertaining to bona fide requirement, the learned first appellate court came to a finding that the plaintiffs did not have a bona fide requirement, would not prove the bona fide requirement of the suit premises. it is so relevant to take note of that pursuant to the judgment and decree passed dated 30/8/2024, passed in title appeal number 10/2022. The plaintiffs filed an application seeking review, under sections 114, read with section 152 and 151, for correction of certain typographical error in the judgments. The said application was allowed by an order dated 17/9/2024. It is under such circumstances the present revision application has been filed. This court had duly heard the learned counsel appearing on behalf of the petitioner as well as the respondents. And duly considered the submissions so made and have duly perused the judgments passed by the learned first appellate trial court as well as the learned first appellate court. The question which arises before this court is as to whether in the present facts this court should exercise its revisional jurisdiction under section 415 of the code, or for that matter, whether the learned first appellate court had exercised a jurisdiction not vested upon it by law, or had exercised its jurisdiction illegally and with material irregularity. The learned counsel appearing on behalf of the petitioner, who is the defendant, could not place before this court any materials on the basis of which this court can come to a finding that the issue can arrive at a different conclusion, that the jurisdiction so exercised in respect of issue pertaining to issue number 3 calls for an interference. There's a complete failure on the part of the petitioner to show that there is any perversity in the findings. This court has already, in the previous segments of the instant judgment, opined that though the petitioner hearing, who was the defendant, had claimed that amounts were duly paid, that the rent was tendered to to the Pranab Saha, and to Pranab Saha by issuance of checks for the period from August 2012 to August 2014. But there is no materials shown before the learned trial court. There is no materials placed by way of evidence that the plaintiff, that the defendants, that those checks in question were at all encashed. Under such circumstances, the findings were arrived at by the learned first appellate court to the effect that the plaintiff, that the defendant was a defaulter for the period from September 2012 to August to July. August?
Yes, madam.
To July,
July 2000,
to July 2015.
September 2012 from July to July.
July 2014. cannot be interfered with. This this court further finds it relevant to take note of that at paragraph number 14 of the claim, the plaintiffs have claimed that they require the suit premises for expansion of their business. This court had duly perused the written statement filed by the defendant. Wherein they have, though they have stated, though the defendant have stated that the suit premises though the defendant have stated that irreparable loss and injury will be caused to the defendant if the suit is not dismissed and the defendant would face the closure of the business. But there is no mention in the written statement or even during the or even during the in the instant proceedings that the defendant during this long drawn battle, legal battle, had made attempts to look for alternative places for carrying out its business, and the defendant could not find any. This factor is a very relevant factor while deciding the question of bona fide requirement of the landlords. This aspect of the matter can be seen from a recent judgment of the Supreme Court in the case of the case of paragraph 28 to 50. In the opinion of this court, that though the learned first appellate court had arrived at the finding that the plaintiff did not have a bona fide requirement of the suit premises, but this very essential factor was not taken into consideration. In the opinion of this court, therefore, the findings were arrived at by the learned trial court in respect to the issue number 7 is required to be restored. Considering the above, this court finds no ground to interfere with the interfere in exercise of its division of jurisdiction for which the instant petition stands dismissed. However, in the facts of the instant case, this court is nothing. ಇದು Justice Vishwanath Manoj.
Item three,
Yes. But it's challenging.
I have no other option to lose. And because of that, I find
What do you want?
just, I need to one more time to file the evidence.
Huh?
One more time to file the evidence.
You have yourself have stated you don't want to adduce evidence. Isn't it page 36?
Proceed.
Are you going to blame the lawyer? Raise your petition 8711.
87 that has not been. Only the order.
You have a counterclaim? You are the plaintiff.
I am plaintiff.
You are the plaintiff. And why is the court hearing it? You have not given evidence. Defendant has not given evidence. What is there?
Because of that, I did one more time.
Huh?
Because there is one ground that the cost imposed by the trial court that has not been paid by the plaintiffs. Because of that, this order has been passed. 28, 22, 8,
When was the date fixed for filing of evidence?
that is 22, 8, 2024 is the last date.
No, Mr. Counsel, what are you doing is this. You have just brought an order of 22/8/2024. You are challenging in the month of May 2025. Why should this court at all hear it? Yes. Well, dismissed.
You lost me for some cost you lost.
What?
Cost you lost.
No, first of all, why should I? First of all, why haven't you brought on record any application? Nothing. Your petition is devoid means there is nothing. You have just enclosed what? A copy of the plaint? Okay?
Yes.
Then,
And the order.
then the order of 22/8
Then.
and
19. Then the last petition. was.
petition under 151 for vacating the order granting leave to file plaintiff is presently working at Nalbari to sustain his family and livelihood and as such could not appear for filing evidence. Plaintiff is currently suffering from jaundice. What has happened to this?
That has not been disposed of.
Where is that order?
Last.
Huh?
Page 30.
Page?
Vacating the act.
This petition was filed when? This
On
is filed after 12 p.m.
2024, I had filed one petition.
Put up on the date please. That is on 1911.
1911.
Then on 9/12. Today is the date fixed for arguments. 9/12 for arguments. Today the day, however, the plaintiff has paid for advancing both parties are here paid. Both parties are directed to advance around the next day PR, which is heard and allowed. Your petition has been allowed.
Allowed it. This is 1911. Order doesn't say anything.
So you should go there. You should be happy. No, no, here you see, later on, plaintiff side is represented by the engaged counsel, 1911. Okay, fixed as before for arguments. Then plaintiff and defendant, today is the date fixed for arguments. However, the learned counsel by petition number so and so, this is 8711. Yes, 8711. Has prayed for another date to advance hearing by showing cause which is heard and allowed. Both parties are directed. What happened on 7-3? What happened?
7th, nothing happened.
Then why you are not going before the court and asking for the disposal of this application? Go there. Withdraw, withdraw. This type of petition should not be allowed.
I shall file another petition.
Go there, there is already an order. Go there, fight it out. The counsel appearing on behalf of the petitioner submits the taking into account that the application so filed being petition number 8711 of the 2024 having not yet been disposed by the learned trial court, comma. The petitioner herein would not like to press the instant petition. However, the withdrawal of the instant petition should not prejudice the petitioner in in respect to the consideration of the petition number 8711 of the 2024. So taking into account the above, the instant petition stands closed on withdrawal. So it is observed that the withdrawal of the instant petition shall not prejudice the petitioner in the consideration of petition number 8711 of the 2024. Bracketed there, if not yet disposed of.
Already. Right, is it? Lord, one is painting. As the instituted suit for seeking declaration. And also for passport. So, my lord, we have filed a written statement.
What are you challenging?
Beg your pardon.
What are you challenging?
Fine, after 15 years, they filed an application under order 7 rule 14 subclause 3. I'm saying that two of the documents, they did not annex. In the cross examination, when we asked them the question, whether you have those documents.
Which order you are referring to?
That will also find it. 30.
Hmm?
30, order dated 39/2024.
Page?
At page 30. Petition number so and so filed with the petitioner plaintiff under order 7. Rule 14(3) read with 151. That is the Mies case. Both sides are represented. The contention of the petitioner is that the connected suit has been instituted by the petitioner plaintiff seeking inter alia, declaration of right, title and interest, recovery of possession, cancellation of orders and instrument, etc. in respect of the suit land. The plaintiff claims to have acquired title of the suit land by right of purchase. The flow of title has been adequately pleaded in the claim and also been substantiated during the stage of evidence. That though the foundation was laid with the pleadings, but the seal number so and so executed by so and so, seal number so and so executed by so and two others were not produced in the proceeding due to our site. The same documents are the main title deeds and the foundation of the plaintiff's entire claim. As such, it is prayed to allow the plaintiff side to produce the same document before this court and allow the plaintiff to execute the same by way of re-examination of the pleaded part. I have heard the learned counsel both sides, though the learned counsel of the office side has received a copy of the enforcing petition, but they have not filed any written objection in this case. I have perused the entire case report on the contents of the petition. It appears that the aforesaid two documents are necessary
for just decision of the main suit. As such, a production of the same gives for this court is required. Moreover, the officer is not filed in application. So this application, well, it is not that, it is their own document. Their safety. Now it is one, it is in their position. And at the time of, the examination, we have cross-examined whether you have these documents. So they are in no of the thing, well, they are producing evidence. That is in the year 2020.
What is the judgment you are referring to?
So in regard to,
Page 49.
here you should see that whether due diligence has been exercised. I just try to refer judgment to the Madras High Court.
No. What are you referring to? Page 49.
Opinion, in a similarly situated position, my lord, he came, my lord, we also did not, we paid for the court to reduce, to bring two documents. Now that was rejected, my lord, in the earlier occasion, for our documents are concerned. Now,
But have you
my
adduced
lord,
evidence? Have you adduced evidence?
Yes,
Then what is the stage of the suit?
my lord, it's in the final hearing.
Huh?
The argument stage. Evidence has been closed long back in the year 2020. The judgment, my lord, we filed just to persuade your lordship that in the similar circumstances, when we called for the documents, it was dismissed because we came in a later stage.
Now, during his evidence, he did not exhibit these documents.
Exactly, we have stated all these grounds also. Even this is his own document. At the time of cross examination, put him those questions. Even then, he did not come at that relevant time. Also. Now he has come now after more than 14 years. Now due diligence will be required to be exercised. My lord. Stage cannot mean that at the stage of,
So this is actually an application under 151.
Lord, how
Why is he seeking leave? Why is he seeking leave? Where is his petition? Petition number
Well, yes,
481.
that petition, your lordship kindly see. What amendments he has made at page 61.
Page
61. An application filed under order 7/14/2021. So the connected suit has been instituted by the petition of plaintiff seeking declaration of right to interest, recovery of position, cancellation of orders and instruments in respect of the suit land. The plaintiff claims to have acquired title of the suit land by right of purchase. The floor of title has been adequately pleaded in the claim and also been substantiated during the stage of evidence. The suit land originally belonged to so and so. One of the successors, Fatima Begum, transferred the suit land to the intermediary purchaser. There is vendors of the plaintiff who eventually sold the suit land to the plaintiff by UFT registered instruments which are, number 1 and number. Then paragraph 3. That though the foundation was laid in the pleading, the aforesaid deeds were not produced in the course of the proceeding, presumably, the lordship can be seen, presumably due to oversight of legal and guest counsel. It may not be out of place to state that the plaintiff petitioner had submitted all the relevant documents to its counsel and based on the same, the plaint was drafted. However, it is learned that the English counsel at the relevant point of time was not of the best of his health, for which he was heavily reliant on it. It is under such circumstances that the said omission may have occurred. The said deficiency was only discovered by the newly engaged counsel, who had entered appearance on behalf of the petitioner plaintiff on so and so. The petitioner plaintiff begs to submit that the aforesaid documents at the main title and the foundation of the plaintiff apparently. The said document being same documents are therefore required to be examined so as to effectively decide the suit in question. The matter of fact, no effective adjudication can take place. The absence of the same document in the interest, substantive justice, the same may be permitted to be brought as a court. The petitioner plaintiff further has to submit the defendants of opposite parties have had sufficient motive to stand in plaintiff and are also aware of the appropriate. So there is no likelihood the defendant being taken by surprise or by prejudice by the larger instruction. Moreover, the documentary question when registered carries presumption of verity. But in so far the delay is concerned, the petitioner plaintiff regretfully submits that he, having handed all the relevant documents to his counsel, was under a bona fide impression that all vital documents of type produced by the doctor. The petitioner plaintiff was instituted and is currently not in position to speak out. Hence, there would hardly be any intention to delay on his part. The delay therefore is completely unintentional. That is the oversight and inaction of the council. Now he has, my lord, given the all blame to the council, even he did not write the name of the council, he ought to have included him as a party. I wonder whether he has given a complaint to the bar council to close up the connection. Nothing of that sort. Now, it's very easy to give a blame on the council. If he's doing his day-to-day works, he could have understood that, well, the important document should be annexed. And then whether maybe he exercises the due diligence in the matter, that has to be seen. The stage may not, my lord, I think, at the stage of hearing. In the appropriate stage, he is required to come.
What were the other documents which we could not produce earlier?
So that we came here, my lord, was rejected. Challenging up to the appeals court, they are also requested.
Bingo.
So these are the, you know, it's a municipal land. We purchased from one of the, the person. And then one has gifted us 6 cutters of land. Now these documents are there.
You could not produce.
Beg your pardon. It was
You could not produce.
filed an application. That came here. That was also not given any credence. When after the appeals court.
And why are you challenging this order today?
So the only thing, a little bit delay apart because.
5/4/2025, when that order was passed on 39/2024.
Very correct, Madam.
Why after such a?
We were asking that certain document.
I'm not on that. I'm asking you, why have you challenged the order of 39/2024 on 5/4/2025? What is your explanation?
Hello, your lordship's queries regarding order dated 39/24.
Why?
So that is partly negligence of our client.
So we dismiss on that ground?
There was some delay on their part because now the only thing, you know, if I can impress upon your lordships by that.
Why didn't you file your objection then?
So I am told that they wanted to file an objection, but then I did not submit that because the
So you must have filed a petition then.
order, something, order of the learned judge is there. So if I read it, that is moreover, the opposite party side has not filed any.
So the
objection.
learned counsel for the OP side has received the copy and the aforesaid petition, but they have not filed any objection in this case. Then
Let me know. Now, the council say I verbally requested the court to give samples so that.
Verbally, the things does not work.
My lord, I'm aware of that, the reason, my lord, I did not make. this.
Verbally does not work. And this petition was filed on second of August, 2024. And the next date was fixed when? We had enough time. Receipt copy, objected to. Verbally,
receipt copy,
advocate
9/8,
9/8/2024.
So far, this question is concerned, my lord, your lordship is very right. Because, my lord, they ought to have been very prompt on this thing.
Then why
Now-
should, why should I exercise 57?
Your lordship, very correct, so far that question is concerned. That's why I never paid, my lord, that,
We'll cross-examine him.
that part is okay, my lord, but the.
And what has happened in the meantime?
The meantime, my lord,
He must have given evidence.
evidence is already closed.
No, this, after this order,
After this order, my instruction is yet to happen.
how? How is it possible? When that application was allowed, where is the,
That means your lordship, so far that instruction, precise instruction is concerned. Your lordship take it tomorrow, and from your lordship what happened. President, my lord, can I take your lordship to the question of the,
no? I'm going on the question of belief and laches.
then that so far we are concerned. But then 14 years delay of post,
So what? You should have objected. You did not file any objection.
but then orally what the council is saying.
Orally, the civil
Yes,
court
I
does not
understood,
work.
but Oral witness, if the court of law has got no meaning. But I-
Orally, nothing works out. The orally, people may work in the high court, not for the trial. You may have filed a petition. You want to file an objection, you have to file a petition. Because the next date was fixed for objection.
Very correct, as your lordship is asking me, I asked my client also what he did. And, the reply was that my advocate was verbally requested the court, but the court did not apply. That was the reply the instruction I received. So therefore, my lord, this is a very pertinent question and
And in the meantime, if the suit has been disposed of,
things, so my lord, that's the reason, my lord, your lordship take it tomorrow, I'll take the precise instruction.
is the matter tomorrow at 2 p.m.
Item 5,
Here's the sake, what you are
here
challenging.
in this case, there was a decree in my favor of 3 lakhs of rupees along with interest, 6% interest, and cost of rupees 16,075. So your lordship would be pleased to turn to page 35, the decree,
Page
35.
Yes. Then,
Now what happened, my lord, they did not pay this amount, decretal amount, then I filed a execution case. Execution case claiming rupees 5 lakhs, my lord, with interest and cost. So thereafter, my lord, there was a negotiation. There was a negotiation that they will pay 3 lakhs rupees to me. And after that, my lord, a negotiation arrived at and 2,000 rupees was paid to me.
Huh?
2,000 rupees was paid and another amount will be paid later on. So, my lord, your lordship will turn to page 5,
what are you challenging?
challenging the order, my lord, last page.
Come to the point.
Yes, my lord, last,
Yes.
last
What
one,
are you challenging?
last,
Page 53.
last one, last page.
Yes,
Yes.
why are you challenging?
53. Here what happened, my lord, that I received rupees 2 lakhs and agreement was of 3 lakhs. Now what happened, my lord, that is temporary. And it is written that I have received rupees 2,50,000. 2,50,000 I have received, so nothing remained for due. So against that, my lord, they came with a petition that I have received this 2,50,000, so there is nothing remains due. Against that, I file objection. In the objection, my lord, after that objection, the witnesses were examined. They said that there is tampering with the agreement. Thereafter also, my lord, this impugned order has been passed.
What is wrong with the impeachment order? What is your name?
Abdul Qadir Mian.
Did you give evidence? You gave evidence.
Yes, my lord.
Where's your evidence?
Evidence, my lord, I'm- Uh, 44, page 44 onwards.
Whose evidence is this? Who is Abdul Salam?
My lord, he is the person, my lord, who signed the agreement.
Who is Abdul Salam
Abdul
vis-a-vis
Salam is
of whose witness?
witness of this agreement.
Whose witness?
In the, it is the court witness. It is recorded as court witness. Your lordship will turn to page 44.
That I have read it. He says that you have, judgment debtors have paid rupees 2 lakhs.
Yes.
Then,
My lord, I have received 2 lakhs. They tampered with the witness, they tampered with the document.
for what?
They tampered with the document and said that I have received rupees 2,50,000.
No, the court passes that order.
My lord,
It appears the judgment debtor have failed to establish the payment of rupees 2,50,000 as agreed upon by the parties during the compromise. So the claim of the decree holder that they have not got the entire rupees 2 lakh appears to be correct. You are the decree holder,
I am the decree holder.
so it is correct. Now, as the decree holder has
Well,
admitted to
Here-
have
here
received
is
2
the-
lakhs.
Here is the mistake on the part of the court, my lord. It
Why?
held that amount of 2,50,000, that is not the case. Amount is 3 lakhs. Amount is 3 lakhs. That is why, my lord, I am referring to your lordship. That agreement, your lordship will please to see at page 40. Page 40, 41,
So kindly come to page 44.
44. Yes, my lord, 40. 44, my lord. CW1 is the aforesaid CNC is my signature. As per negotiation, judgment debtor paid rupees 2 lakhs to the decree holder in our presence and undertake to do remaining amount after construction of the embankment.
Then,
So, your lordship, just during negotiation, it was resolved that judgment debtor will pay rupees 3 lakhs in cash and repair embankment between so and so near so Bazaar as a condition for withdrawal of the execution case. So, my lord, here amount was 3 lakh. Your lordship just see this agreement, my lord. Agreement, it will make clear, my lord. Page 40. What they did?
Yeah.
Page 4.
page 40 is the type copy.
My lord,
Page 41 is what?
agreement I am placing.
And then? It is written in words also.
Your lordship, and see page 41.
It written in words also.
My lord, it is written in words also, but it is strike down. Your lordship will see.
What is strike down?
It is not typed out. It was a typed out one, but eraser was used. That is our case.
Are you
Evidence.
saying
Hello.
the name which have been mentioned as I Sri Abdul Qadir Mia, son of Ahmed
So-and-so.
Ali Haji.
Haji,
Why did you allow this? Was this Ahmed Ali Haji was there earlier or not?
hello,
Was this name Ahmed Ali Haji
Ahmad Ali Haji.
was there when you signed the document or not?
Ahmad Ali Haji is my father's name.
Was that name written by hand when you signed the document or not?
That, I have to say.
This is what? Then why you are saying that all these things out there that have received that amount of the, all this amount is blank? Then why did you sign here on a blank document? Then? Thing wrong.
Bank document means, my lord, this amount, my lord, but the evidence will go.
Evidence has been looked into and he
Evidence-
says that it is
No,
two
but
lakh fifty
Evidence,
thousand.
evidence is looked into, but your lordship would be pleased to see this is the strike down one.
The sake,
It
I
is not
mean,
typed out.
it's the sake, I mean, 227. Thing wrong. Help it. You get 50,000.
Oh, my lord, it is 5 lakhs rupees, my lord. It was 5,60,000.
Understood, it may be a crore also,
Right.
but you have agreed into a particular agreement.
It is totally.
Now,
temp-
in that
it is totally a
agreement,
tempered document.
no, the question is, in that agreement,
No, no.
the word used out there, did you sign that agreement or not?
Yes, I signed.
Understood.
Yes.
Now, if you have signed it there, now you are saying that one portion it is blank. You're saying that.
Yeah.
Why on earth did you sign the blank portion?
No, but look, I am not saying that one portion was black. I
It
am
is
saying,
blank.
no, but look, I am saying that it is tempered with, it was 3 lakhs. It was written to 2,50,000 later on,
Earlier it was what was written earlier?
3 lakhs.
Where is the 3 lakhs?
That 3 lakhs was there, but that has been erased away and right this, 2,50,000.
So did you file an
your-
objection
your
to that
lordship-
effect?
Your lordship, see another document, your lordship, here your lordship has put page 40.
Now, first of all, did you give evidence?
My lord, yes, evidence has been given, that has been examined as court witness. All are recorded as court witness.
Oh, your evidence.
But all evidence are evidence, those who have signed as witness in the agreement. And those were examined before the court. And they specifically said that it was 3 lakhs rupees. 2 lakhs was given and 1 lakh remained due. All evidence has been said, all witnesses say. Now your lordship will turn to page 40.
I have read for no case.
My lord, your lordship would be pleased to see page 40. Page 40.
On Abu Salam, I'm not saying that these are evidence which are court witnesses. These are witnesses.
Witnesses, but it is
did you
recorded as
adduce-
court witness
Did you adduce evidence?
from my side.
Absolutely. You are only alleging
Well, these are my witness also, and I myself.
and
examined-
your witness, if he is your
Well, but
witness
I-
at page
I
44.
examined myself as
Okay,
witness number 4. Now your lordship will turn to page 40. I'm insisting on page 40, madam.
yes. What is that?
It is written money receipt, madam.
Ah.
Money receipt, it is said that I have received rupees 2,50,000. If I receive rupees 2,50,000, madam, my humble submission before your lordship, this is their document. Their document they produced, they said that I have received rupees 2,50,000. It is a similarity with the agreement now, present agreement. But I am not denying, I deny that. Now 2,50,000 I have received. If that is their document, my lord. Now court says that I am entitled to 50,000.
No, the
Why
court
I
said, court said that they could not prove that they have paid you 2,50,000.
in that case, my lord, in that.
So
case,
therefore, but you have admitted to have received 2 lakhs.
Now your lordship, in that case, my lord, case 40 document is a false document produced by the authority. It is a false document produced by the authority that I have received rupees 2,50,000. if I have received, if this document is disbelieved, my lord, I have nothing to do. No amount is due to me, my lord.
Raho. Heard Mr. M.A. Sheikh, the learned counsel appearing on behalf. Sir, we are Gogoi, appears on behalf of the respondent. 1, 2, and 3. This court, the instant proceedings is in proceedings under section 100, article 2 to 7 of the Constitution, challenging the order dated 13/11/2024, passed in money execution case number 3 of the 2016. Pusta, taking into the scope and ambit, taking into account the order which this court proposes to pass, the instant proceedings is, this court, taking into account the order which this court proposes to pass, comma, takes up the instant application for disposal at the motion stage itself. Pusta. The materials on record show that a judgment and decree was passed on 7/8/2015, whereby an amount of rupees 3 lakhs along with interest at the rate of 6% per annum was decreed in favor of the petitioner, who is the plaintiff, from the date of institution of the suit till full and final realization. First, on the basis of the said judgment and decree, an execution proceedings being titled execution case number 3 of 2016 was filed by the petitioner. First, the record reveals that during the pendency of the said execution proceedings, an amicable settlement there was an amicable settlement between the decree holder and the judgment debtors. Pusto. It is the case of the petitioner hearing that as per the amicable settlement, the petitioner was to receive rupees 3 lakhs, and out of which rupees 2 lakhs was paid and remaining 1 lakh was to be paid at the time of withdrawal of the application seeking execution. Per contra, it is the case of the judgment debtor that the amicable resolution, amicable settlement pertain to payment of an amount of rupees 2,50,000 in total to the petitioner. Pursuant thereto, pursuant to the amicable settlement so recorded on 31/3/2022, an application was filed by the judgment debtor stating that an amount of rupees 2 lakhs was already paid to the petitioner on 31/12/2022. And as such, have an amount of rupees 2,50,000 has already been paid to the petitioner. And as such, as full and final settlement of his claim, and as such, the execution proceedings is required to be dropped. On the other hand, the petitioner filed an objection to the effect that on 31/3/2022, the deputy commissioner had paid an amount of rupees 2 lakhs by taking the thumb impression of the petitioner. And the remaining 1 lakh was to be paid at the time of withdrawal of the said case. It was categorically mentioned in paragraph number 3 of the objection that the amount of amount was erased and was and an amount and further an amount of rupees 2,50,000 was was handwritten, which is forged and manipulated. On the basis of the said allegations so made, the learned executive court examined two witnesses who were witnesses to the said deed of settlement. And pursuant thereto, three witnesses who were witnesses to the said deed of settlement. And pursuant thereto, three or four
Four is the
four
petitioner.
witnesses pursuant to the said objections. And passed the order on 13/11/2024, wherein the learned trial court, executing court came to an opinion that the judgment debtor had failed to establish payment of rupees 2,50,000. And as the decree holder had admitted that he had received rupees 2 lakhs, a warrant of attachment was to be issued for recovery of the remaining 50,000. And it is under such circumstances, the petitioner had approached this court. This court had, upon hearing both the parties, had given an anxious consideration to the matter. From a perusal of the impugned order dated 13/11/2024, there is no finding arrived at by the learned executing court as to whether the amount which was amicably settled was rupees 3 lakhs or rupees 2,50,000. Considering the above, this court interferes with the order dated 13/11/2024, directing the learned executing court, that is the court of the civil judge senior division, to decide as to whether the amount which was arrived at by and between the petitioner oblique the decree holder and the judgment debtors oblique the respondents was rupees 3 lakhs or rupees 2,50,000. And on the basis of such findings, on the basis of such orders and findings, proceed with the execution proceedings in accordance.
For admission, item 6.
Yes, what is this?
The revision petition challenging the impugned order by which the petition under section 11 has been allowed, holding that the suit is barred by res judicata, and ultimately the suit was dismissed. The case was at the stage of pleadings, issues were not framed. At that time, along with the written statement, an application was filed under section 11 of the CBC, stating therein that this suit is barred by res judicata. Objection was filed, and after that it was.
Who is your senior?
Yeah,
Yes. Where is he?
461.
Let me dictate the judgment in his favor by the time I ask him to appear. Okay? Where is the judgment?
The impugned order is at page number 34. Page number 34, operating part starts from page 35. Bottom portion. Chief, the first submission is that the principle of res judicata is a mixed question of law and fact. Without having decided the issues pertaining to the challenge to the issue that is there with regard to the facts, how can the law directly be applied? Here in at page number 38, it has been held. Accordingly, it is found by this court that the issues which are raised in the present suit, that is title suit 56 of 2022, are already decided in title suit 107-201 by the court of competent jurisdiction of London so and so, by judgment and dated so and so. Now, issues have not yet been framed here. How can the court determine that the issues that have been raised in here were the same issue there? And with regard to the predecessor and interest that they have alleged that they are my predecessor and interest, which I have denied in my objection, how can the court come to a finding, determinative definite finding that these are my predecessor in interest? And the land, suit land is also similar because in the earlier suit, but it seems from the documents that there was recovery of possession for a plot of land measuring 2 bighas only. And here it is entire 10 bighas is on challenge. Recovery of possession with regard to 10 bighas of land. So even the suit land is different. And moreover,
My question is, it has been dismissed.
it has been dismissed.
And what happens when it's
If dismissed, then it amounts to take through. But herein, though no adjudication is there and it is not even return of claim.
there is litigation? Has been rightly, wrongly dismissed. Has been dismissed. What is the course of action?
Course of action is appeal.
How do this court exercise? Because since it is dismissed under order 711 also, it taken under order 7 or B. Court had made it clear that it is a decree. And as such, an appeal lies there against. But it is on the other hand, when an application is being filed, seeking rejection of a claim, and that application is dismissed, then it would result to filing an unsuitable. The suit having been dismissed, how do I exercise hundred?
But if the problem here is that this is neither for rejection of the plaint nor for the return of the plaint, but directly a petition under section 11 of the CPC, which is not heard of. And under that application, once that application is allowed, then directly the suit was also consequentially dismissed. Without there being any issues, without there being any adjudication on any.
Wrongly done. There's no quarrel, Mr. Counsel, there's no quarrel. The question is, how do I exercise my jurisdiction?
We converted once.
People,
What we are.
but we'll take it up. It's the only way. If I do it, 115 here, everywhere the question will come. Any other council out here will come up with that judgment. We have a good case, but the case is, I can't.
Given the liberty to file the court claim. File the court claim.
It is seen. There is a consequential order, no?
Consequently.
Yeah.
That is at page
It
40.
is seen that on the basis of an order being passed in Nizze case number 89/2022, which was taking dismissal of the suit under section 11. The suit have been dismissed. And consequently, the said application has been allowed. And consequently, an order has been passed in title suit number 22, number 56 of the 2022. Dated 22/5/2023. Holding inter alia that the suit being dismissed as hit by section 11 of the Code of Civil Procedure. The manner in which the learned trial court exercised the jurisdiction appears to be akin to a proceedings under Order 7 Rule 11 bracket D of the code. Major senior. I've written so much, I think we should allow it.
Has some objection, Lordship.
What objection? We can have no objection. I only want to record your name. Because tomorrow when I do it in your presence, your senior may sue. Otherwise, there is nothing else. Authentically. It is also a tried principle of law that a question of res judicata cannot be decided in a proceedings under Order 7 Rule 11 as has been held by the Supreme Court in a plethora of cases. Be it as it may, when a suit is dismissed, it amounts to a decree. And as such, the appropriate forum, appropriate manner, what is the value of the suit?
So the suit is 5,50,000. At Veloram court fee of 6,443 is paid.
Go there. Go there. You go before the district judge. My jurisdiction is above 2 and 3. What to do? I'll take it up at 2. I'll see if I can convert it into 2 to 7 and then exercise. LCR is here,
LCR.
but I can't exercise under the CPC. Civil I can't do it. Appeal I can't. Value of the suit is 5 lakhs. I can't. And if I remand it, goes to the district judge. The district judge again, unnecessary time spending for another 2-3 years. It will take some time. So we convert it to 2 to 7. And saying it to be shocking, interfere with this order, and therefore the consequential order, and direct the trial court to decide. This is the only way out. Let us senior come. You get hold of me, the judgment of Justice Chandrachud. Section 11, Order 7, Rule 11.
Yes.
You know,
Submitted one copy of that.
I did. Let me at 2 o'clock. This one, nah? Which one?
One Totla. P. Haridas Hanuman Totla versus M. Vithal Kamath and others. That's page paragraph 20.
This one. Hanuman Das Putala.
Cannot
Where it has been held, now you cannot decide.
decide.
Hello, this is there. And we do one thing, we'll do that. Exercise 2 to 7 and get all of your senior, what objection will speak.
Deeply honest.
Item 7.
I've been engaged. I've seen.
New council, tell me,
Last
where is that application under order 23? Rule
That
1?
application we had on Friday, that has come out of the court.
Huh?
On Friday, that has been filed. By the petitioner, the application filed before the trial court for return issue, that is not on the court. And affidavit has been filed annexing that petition, that is not on the. Okay,
Hello?
we take this on Friday.
No, if you don't show any urgency in the matter, we'll have it after 6 months. We don't have a stay also. What are you challenging here?
The question is, also the application filed for withdrawing the suit is liberty. That application has been rejected by the trial court on the ground that there is a provision for amendment of the plain. Without amendment, you can insert these facts by amending the plain. And against that, he has preferred this petition.
Why do you want to withdraw?
Only because originally the case was filed by the plaintiff, stating that they have defendant has purchased the suit land, different land, and occupied the suit land of the present applicant. But during pendency of the suit, it has been realized that defendant has purchased the land from one attorney holder, inserting the name of the legal heir, being legal heir of my forefathers, fraudulently the RKG branch of the Revenue Department. That fact was not within the knowledge of the plaintiff at the filing of the suit. That fact was not brought on record. That the other,
When did you come to learn?
he came to know subsequently after filing.
When?
After watching the starting of the evidence, they realized. Plaintiff evidence has been started.
Are you sure?
Instruction given by, as per instruction given to me, Lordship, they came to know regarding these facts when the plaintiff was cross-examined by the defendant.
Then why you are not? So there must be something written in the evidence of the plaintiff.
Plaintiff evidence, they have stated that they have occupied some land, purchased another land and occupied the land of the plaintiff.
Upon that. And cross-examining the plaintiff witness. Plaintiff come to learn, na?
According to,
So therefore, it will be there in the document itself, in the cross-examination itself. That such questions were put.
cross-examination, but I have not seen, Lordship. According to my advocate who is hearing in this particular case, they have said that at the time of
Mr.
cross-examination-
Goswami, if you are not ready, don't do the matter. But I'm going to otherwise dismiss your matter.
Lordship, that is why, Lordship, on Friday, Lordship, that
No. This will go in the month of July. It is seen that the matter has been listed from time to time.
22, Lordship, I have said the 22. This application has been filed in 2022.
Understood. Matter has been listed after time, from time to time before this court. And it is seen that this court, by the order dated 25/5/2025, have directed the plaintiff, the petitioners to bring on record the application filed under order 23 rule 13, along with the objection so filed.
Friday, it has been filed.
It has been mentioned by Mr. S.K. Goswami, the learned counsel for the petitioner, that such such affidavit bringing record those documents have been filed. Who's to leave the matter for 2 weeks.
Others.
8.
Shall bring on record this. Yes, what is this, Mr. Rashid? What are you challenging?
Getting the injunction, similar, I have a two channels of them there.
Huh?
And, there is a road, entry road, measuring, 7 feet and 100 feet. And that is going on till the road is there. So there was some order, so we have filed a issue and the issue is pending and we filed with a miscase, my lord. That is 24/22.
So your injunction was not granted,
Yes. Once it is granted, subsequently it is vacated, I will file a.
and that was granted initially,
Yes.
ex parte. And then that was vacated by the trial court.
Fine.
And thereafter, the appellate court also dismissed it, and you are therefore before this court.
Fine.
So what is your ground for injunction?
Hearing Millard, first of Millard, we have parcel the land, Patta land, and there is entry road.
Huh?
Entry road. Approach road, Millard. And that is Millard. And it is Millard,
Approach
regarding
road
your
belongs
that
to
is
whom?
our land, in our deed Millard, shall be Millard. that is
Mr.
Millard.
Rashid, approach road belongs to whom?
And this Millard is for my deed Millard, it is my land.
Right title and interest.
And city is the
Enjoy
Millard.
over the suitable
That is
disturbance
the Millard should land.
You have purchased this schedule B land.
A land Millard, that is.
I am not on A. Schedule B land.
Schedule B is mentioned there, that is the entry.
Asking you, have you
Yes, sir,
purchased this land? It belongs to whom?
We have purchased, I have purchased the same Millard, from Millard University, and I have seen them that we. Yes. If you never send it to government school our.
Why did you file the suit? Huh?
There was, An order was passed by the Virat SDC, sub-division, SDC Virat, yes, circle officer. And against that order, also they have not annexed the same Virat, and that order was Virat, not to Virat, it means to close the entrance, Virat.
Huh?
To close the entry in Virat. That's not annexed the same.
Yes, Mr. Putter, what is the case?
I am appearing for the meeting had for one, two B and two C, what the petition I have collected from, I have not received any summons, any notice. On just search, they have. They have instructed me to appear. Direction may be given to private copy. Here, located in the order sales. Orders have been uploaded in the website. Parties have been shown 1, 2, 3, 4, 5, 6. Government council has been shown as 3 and 4. The parties other name have been mentioned as 5 and 6, someone have been served. But here the copy has 1, 2, 3, 4, 3. Particularly, no someone has been served on 2B and 2C. As per this petition. Very in list also was it. Government advocate has been shown as respondent 5, 6.
As per order, we have taken steps, and immediately I will start something with the paper.
So a copy will be served will be there, then matter will be taken up in the next.
Who was the owner, Mr. Rashid? Who was the owner of this land? It will be. You are not the owner.
Yes, I have accessed the same.
You have not. Who has executed the sale deed of 99, 21,999?
2199 is Mr. Prabhat Chandra, he told me.
Prabhat Chandra Roy is not the owner of that land. Surendra Kumar Nath is the owner of the land.
And we are what only not.
So you have just mentioned it in the sale deed that it will be a 7 feet road, but Prabhat Chandra Nath had no business out there. He was not the owner of the land. So what has happened? You along with another have got yourself a deed by which that road is yours. You can use that road, but the road actually belongs to somebody else.
On original, yes. And we had got only the 14 gas supply.
Huh?
Only we had got 14 gas supply. That's one. Getting in my level, has been done, but the only entry road will are that is the case.
Yes. Here the defendants, principal defendants have filed an application before the circle officer for demarcation as well as for the purpose of what you call the road, the drain, isn't it?
Rain and road and
To
also.
stop drain used by the plaintiff and so and for demarcating her land measuring so and so. And you want an injunction on that? Notice. You received the learned counsel appearing on. It was that the learned counsel. Then to the TR Gogoi appears for the respondent 5 and 6.
Get bored. But
The supervisory jurisdiction of the court under Article 27 of the Constitution have been invoked, alleging the dated 13/9/2000 passed by the passed by the Civil Judge Senior Division Gwalpara in Miss Appeal number 4/2023, whereby that said appeal was dismissed, thereby affirming the conviction of the application of temporary injunction by the learned in Miss case number, is a case number 20. I think after that, suit number 47. By the court of the learned. We come back 1 o'clock. It's of the petition hearing that he had purchased the plot of land which had been more specifically described in Schedule A to the plaintiff entitled suit number 47/2022. The state suit, was mentioned. Schedule B there, Schedule B. Then. Land at measuring 7 feet in breadth and 175 feet in length. Was used by the petitioner. Along with one Abdul Qasim Nick. Since the year of 1999. The respondents 1 to 4, you read. 1 and 2, you read. The defendants, number 1 and 2. In an application before the former defendant number 3. In demarcation. Defendant number 1 submitted an application before the performer. In demarcation of our land and for stoppage of the drain. And the performer defendant number 3 had passed an order on 5/4/2022. And it is under such circumstances the state suit was filed seeking declaration of the plaintiff's petitioner's right, title and interest, and more specifically described in Schedule B to the plain. For declaration that the defendants have no right, title and interest over the scheduled land. Or decree declaring that the other defendants have no right to disturb the plaintiff from enjoyment of the suit land, etc. The said suit, the plaintiff also petitioner as plaintiff has also prayed for permanent injunction, restraining the defendants from invading the plaintiff's right of enjoyment over them and from dispossessing the plaintiff from the peaceful enjoyment of the suit land. Along with the said suit, an injunction application was filed, which was registered and numbered as case number 24 2022. Seeking an ad interim temporary injunction. As well as mandatory injunction restraining the opposite parties of the performer from disturbing the enjoying the suit land until further orders. The respondents herein, who were the defendants in the suit as well as the opposite party in the injunction application, filed objections. And pursuant thereto, the learned trial court, after taking into account the 3 golden principles for grant of an injunction, by an order dated 1/9/2023, rejected the injunction application on the ground that the plaintiff have not been failed to prove, have failed to show the balance of convenience, existence of the balance of convenience in his favor, as well as the petitioner would suffer irreparable loss, harm and injury. We agree the petitioner prepared an appeal being Miss Appeal number 4/2023 before the Court of the Learned Civil Judge Senior Division, Gwalpara. The said appeal upon being heard, the said appeal was heard by the Learned First Appellate by the Court of the Learned Civil Judge Senior Division, Gwalpara, and by the impugned order dated 18/9/2024. Dismiss the said appeal, and it is under such circumstances the present application has been filed. This court have inquired with Mr. The learned counsel appearing on behalf of the petitioner as to what right the petitioner has in respect to the Schedule B land. Learned counsel has submitted that the petitioner have been using the said land since the year 1999. And any disturbance in the possession over the said land would affect rights of the petitioner. This court have also taken note of that the learned trial court as well as the learned first appellate court have duly taken note of the principles for grant of an injunction and have concurrently come to a finding that the petitioner does not fulfill the three golden principles for grant of an injunction. The scope of interference to those findings exercised by the courts, by the court of the first instance, which have been confirmed by the first appellate court, in the opinion of this court, is very limited. Also, this court have also not found that the impugned orders to pass by the learned trial court as well as the learned first appellate court is in any manner unreasonable, perverse, irrational, as well as violates the mandate of the principles for grant of an injunction. Considering the above, this court finds no ground to interfere with the impugned order for which the instant petition stands dismissed.
Timing item 6.
This is your.
You must have informed you.
Lawsuit. See, what I want to say, what I submit lawsuit, since the learned court below has perused the report of the former suit also. So nothing wrong lawsuit.
Understand everything. You will take care of. That is not the. We may get a file immediately. We may know everything, but there is a procedure.
Preliminary issue has to be.
Only preliminary issue. First of all, preliminary issue has to be framed. While deciding the preliminary issue, the has also to come into the finding that from the materials, the plaint, whatever has been stated in the plaint has to be taken as gospel truth. If any issue also. Then only the court can go ahead. Otherwise, the court has to decide it at the time of filing. Only one thing which the courts required to do is examine the parties in terms of order 10. The right thing in the. It have not been done. That is the only way out how you shorten a litigation, civil. Interfere with this order. To the liberty to approach the trial court for proceeding under order 10 clause. That is the only way out, if that can be done, whereby both the parties will be examined by the court and thereupon issues will be framed. Has the issues been framed? No. No. Written statement filed? No, Lord. No. Once you file your written statement,
Written statement has been filed.
if the written statement is been filed, so then the court will proceed on the order 10.
I submit that lordship, the lawyer put no directive to frame preliminary issues first. For lordship, the,
Very good.
yeah,
Ask them.
yes.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the so-and-so who appears on behalf of the respondent. The petitioner herein has approached this court challenging an order dated 5/2023 passing media case number 89/2022, whereby the suit of the plaintiff petitioner, who is the plaintiff in title suit number 6/2022, was dismissed on the ground, dismissed by the court of the learned civil judge Kolkata on the ground that the suit was barred by section 11 of the Code of Civil Procedure 1908. Taking into account the scope taking into account the scope of the instant proceedings, this court would not like to deal with the merits as to whether the suit was barred by the principles of res judicata or not, taking in as much as any findings therein would affect a decision by the learned trial court. But it is relevant to take note of that the applications were filed by the respondents numbers 1 to 6 in title suit number 56/2022 was in fact an application in terms with order 7 rule 11D of the code. And as such, the question arises as to whether such an application could have been, as to whether the bar contained in section 11 of the code could have been decided at the trial, at the stage of order 7 rule 11B of the code. Because the law in this regard is well settled by the Supreme Court in the case of Sri Hari Hanuman Das Totala versus Hemant Vittal Kamath and others, reported in
2021 9 SSC 99.
2021
9 SSC
9 SCC
99.
999, wherein it has been held that the bar as regards res judicata cannot be decided at the stage of order 7 rule 11D of the code. Considering the above, this court is of the opinion that the learned trial court could not have dismissed the suit could not have allowed the application, which was registered and numbered as case number 89 of 2022, and consequently dismissed the suit being title suit number 56 of 2022. In that view of the matter, this court interferes with the order dated, order dated 22/5/2023, in which the case number 89 of 2022, as well as the order dated 22/5/2023, entitled suit number 56 of 2022, and restores the suit being titled suit number 56 of 2022 to the file of the learned court of the civil judge Borpeta, civil judge senior division Borpeta, for adjudication of the said suit in accordance with law. This court, however, finds it relevant to clarify that the observations so made by which this court has interfered with the order dated 22/5/2023, in which the case number 89 of 2022, shall not affect any of the parties in the said suit. This court further observes that the interference so made by this court herein shall not preclude the learned trial court to frame preliminary issues, if so requested by the defendants, as well as invoke the provisions of Order 10 of the code in accordance with law. The LCR of MZ case number 89 of 2022 be returned by the registry forthwith to the learned trial court. Taking into account that both the parties are duly represented, they are directed to appear before the learned trial court on 9th of June 2025. So the registry shall ensure that the records of MZ case number 989 of 9222 is before the learned trial court on or before the next date so fixed.
Deeply obliged.
Yes, Mr. Chaudhary. Where is your opponent?
It is item 42 and
Item 42 is an application, an IA for clarification of your worship order by law. So basically a requisition. And 43 is a matter of content division.
You don't require this matter. IA has no business of it.
And
IA, what am I going to do with the IA?
the worship issue notice in the content book. The content division is a worship issue. I'd like to point out before worship, my lord, in making parties a content division.
There's an appeal filed against this order, na? What happened?
My lord,
Was there an appeal filed against this order? This case? In WBC number 5685 of 2023, no appeal was filed? This, you are asking for contempt against whom?
But in fact, perhaps no contempt would lie against 2 and 3. That will be deleted because they have their hand in glove with the restaurant number 1. That's why they have been made for this. Perhaps your worship on calculation.
Your allegation is that you have not been given the minutes of the year.
My minor threat was given and my lord did not, or in the name of demarcation, they my lord did not put any mark. They said this is your boundary, this is your boundary. Marks.
Issue notice. Returnable on form. 6th of June 2025. This court, taking into account the judgment in order dated 29/7/2024, passed in WPC number 5685/2023, is not inclined to issue notice upon the respondent number 2 and 3. However, as regards the respondent number 1, steps be taken by way of registered as well as usual in 2 days. The case of the petitioner herein is that although the judgment and order dated, by the judgment and order dated 29/7/2024 in WPC number 5685/2023, this court had directed the Circle Officer, Guwahati Revenue Circle, carry out the demarcation as regards the plot of land measuring 2 Katha 5.22 lessers covered by dark number 850 included in KP Patra number 592 under Lubari Mozas Village, Sohor, Guwahati, Part 7. But till date, there has been no steps taken for carrying out such demarcation and preparation of minutes and circulating with the petitioner as well as the petitioner. The respondent number 1 shall bring on record its stand in respect to the compliance to the judgment and order dated 29/7/2024, passed in WPC number 5685/2023, on or before the next stage. What is there with the IA? I can't do anything with that IA.
Worship directed demarcation.
But what do I do with that? My order is very clear. Why do you need the IA for?
Because my lord, the question is how the demarcation is to be made by.
I made it clear. They will make the demarcation. They know how to make the demarcation. They will make the demarcation, prepare the minutes of the meeting and give it to you. That's it. Nothing more than that.
So my lord, the
Don't expect that by way of demarcation, a possession will be given to you.
not a question of position that your worship has clarified, my lord.
For that, the contempt proceedings have been initiated, as you say, that they have not prepared the minutes and given it to you. So they have to prepare the minutes and giving it to you. But what remains in the IA? Nothing. I can't.
My lord, the question is whether my lord, they have to put some demarcation mark or not. That is the, perhaps my lord, that is the clarification I wait there. Because they had gone there. The circle officer has gone there with his staff and said that this is your the boundary, this is your.
No. When a demarcation is being made, they will mention in the minutes from chain is so and so to so and so. This is the land. This is how you do it. They know how to do it. What is there in the IA?
Then your full day can let us. do it properly.
But Mr. M.K. Chaudhary, the learned counsel, submits that taking into account that this court had duly issued notice in the contempt proceedings, he would not like to press the instant application for the present. Taking into account the above, the instant application stands closed. Mr. Liberty, however, is given to the petitioner for the present. Accordingly, the instant application stands closed.
Public.
Petition item 9.
For my learned construct, I am here on behalf of the KBHL. Can it be taken day after tomorrow?
Right? KV, Argue. Argue.
What's it? Next of the case is what's it? The respondent herein filed is title suit, claiming that the property which we have and going to construct a building, construction is going on. That is a HUF property. And it is admitted position that the HUF between us has been dissolved. We are living separately and separate entity. Now they are stopping my construction of the building. With my shop has been gutted by fire. After that, I have obtained permission from the competent authority and started construction. And first floor construction has been done. And therefore, they have taken in the ex parte injunction. And ex parte injunction, we have paid to vacate the ex parte injunction order. And they have rejected the petition. Against that order, we have filed an appeal before this court. And this court remanded the matter and directed to dispose this. And thereafter, again, Lordship granted the injunction order, considering a document of the municipal board that gave the HUF. And admittedly, HUF has been resolved by deed of resolution. And there is no HUF practical. And they say that the plot has been purchased by the petitioner by his own money. They say they want to give a share of the property to the purchasing the property in 2003. And I have concealed the said fact and I have purchased the property in my own name, being thought of. And actually, HUF has been resolved immediately in the plane itself in 1996.
So you are constructing.
Lordship.
What is your status?
Status is first floor costing is done.
Huh?
First floor costing is done. And thereafter, Lordship, the construction, further construction of the building has been stopped by the order of the commission.
Why are you constructing the building?
My shop has been gutted by fire. Hereafter, I started my construction for opening my shop. My shop has been gutted by fire.
You are a tenant? Then
I have purchased the land where I have a shop. In 2003, I have purchased the land.
Then what is this? It's
Lordship will kindly see here plain what they have stated, Lordship. Page 53. Para 17, Lordship. Page 62.
your name, you are some. You purchased it from defend number 9 and 11. Whom have
Lordship,
you
9 and
purchased
11 has purchased the property
from whom?
from Lordship original owner of the land by registered children.
When?
Devi Prasad Kanoe, 2003.
And when was the suit filed?
Suit filed in 2023. After 20 years.
Huh? And they claim what?
They claim that
Last order?
last order Lordship will find at page 127.
127.
Because in the original case, when the ex parte order of injunction was granted, we immediately and filed written statement as the objection. They are asking some documents from the various courts.
Oh, those applications were called, huh?
Lordship.
What happened then?
Then Lordship, ultimately another document has been produced by them saying that there is an HUF with the name of Badridas Panalal, and that document has been considered as an HUF was existence. So trial court has granted it. On the date of hearing, they filed an application enclosing one document.
Document. Were in possession.
Lordship, I'm in possession, I'm comfortable.
So what is the injunction?
Restraining me to construct the building.
Did,
Lordship,
did it?
page 152 is the last portion.
You want? What are you going to do with the construction?
Lordship, I have to operate my business, Lordship, my livelihood.
What livelihood?
I have this shop here, and shop has been burned by fire. That is also the evident position. After that, I have started construction after taking permission by the authority. Construction is going on. Thereafter, they have obtained the expertise in the injunction. Immediately, I have approached their file objection and file a petition for vacating the expertise order. That it is we have purchased it vote in 2003, and they have filed this suit in 2023. The purchase of the land that it should be purchased in of HUF, Badridas Pannalan, and they agreed to give 50% share of the consideration amount, but without accepting their money. We have purchased the land in our own name, so it should be declared as an HUF property, and we should not be allowed to construct.
It's okay. But why are you constructing it? For your own use?
Only,
Not third party?
no.
Let's move to the book.
Thank you, Lordship, when we see at page 148, the finding of the learned judge.
Only 8 letters of land.
The middle part, the Lordship will find. Upon hearing the rival submissions seduced by the learned counsel for both the parties, there exist reasons to prima facie believe that plaintiff petitioner, the co-person of the Hindu undivided family, that is Messrs. Badridas Pannalal as behold, they had submitted important documents in the form of valuation list of municipalities to corroborate their contentions regarding existence of Messrs. Badrinath Pannalal since a long time. As it appears that the relevant documents relating to HUF may be in possession of the opposite party, the document submitted by the plaintiff at a subsequent stage is accepted and considered for the purpose of deciding the matter. To the contrary, it appears from the documents available on record, to the opposite party, Srimati Shita Devi Kanoi and Sri Rajesh Kumar Kanoi are members of the same family and are living jointly, and moreover, it is admitted that there was deed of partnership entered between the parties. In view of the above, it appears that the existence of Messrs. Badridas Pannalal since 1921 is prima facie seen as it appears from the valuation list of municipalities. Being so, the document submitted by the plaintiff petitioner is sufficient to prima facie decide that there is existence of a HUF and above, the existence of a subsequent partnership deed in order to effectuate the transaction of the property has been placed before the court for the purpose of depriving the plaintiff petitioner. Therefore, there appears a existence of a prime case before the court which needed to get litigated with upon evaluation of the materials during the course of that. And being so, the first parameter of existence of the prime case gets established in our thinking. Now, the balance of convenience. When it comes to the question of ratification of balance of convenience, it is for the court to see whether granting of temporary relief to the plaintiff petitioner would cause more inconvenience to the opposite party as that of the inconvenience which the petitioner would suffer if no temporary relief is provided to the petitioner due is fair. In the light of the aforesaid parameter, when the facts of the analogous statute are categorically analyzed, then it appears to prove that the ongoing construction of pillar and casting of roof in the suit land would cause change in the nature and feature of the suit land. And in such a situation, if temporary relief is granted to the petitioner, then the opposite party would suffer from less inconvenience, whereas to the contrary, if temporary relief is not granted to the petitioner, then the casting of pillar and roof would change the nature and feature of the suit land, thereby causing more inconvenience. Then, my lord, irreparable loss and injury. As per the reading
No,
of the
no,
plaintiff-
no. First of all, our case against him is what?
My lord, is an HVF property. And my lord, if you look at the document,
No, 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 no. I am asking you, what is your case against him?
my lord, they are depriving our share. We are the co-person. We are the co-person in regard to this HVF property.
Who has sold this land to him?
Now, these a rental premises for the last 80 years. Their sale deed also they have highlighted that.
I'm
Now-
asking you, who has sold this land to him?
Is the landlord. Landlord has sold the sham land. That is one of the properties.
Who has sold this land to him?
So that you lot will find there.
Page 34.
And if the sale
Page
is 34, lot will find there. 34 in page 34. Devi Prasad Kedia, he is the landlord.
Before.
Then you lot will find Messrs. Badridas Pannala.
Devi Prasad Kedia is who?
He is the landlord. Where the tenant under him.
You are a tenant?
Because your lordship, see in the next page, page 35, Messrs. Badridas Pannala. This is the HUF property. And that indication your lordship will find in the valuation report of the municipality, which is not in the record now.
No, but this is given to Badridas Pannalal, a registered partnership.
Register, what happened, my lord? They have made a registered partnership and just after 1 month, my lord, the finding of the learned judge is there. After 1 month, they have so far partnership business is contract. That has been.
But
Now the
who-
idea is,
But who are you?
my lord, I am the co-person because this is
Co-personers of what?
of this HUF property. This Badridas Pannala. If actually it is an
But
HUF.
are you challenging the registered partnership deed?
Yes, my lord. Now,
See-
now the finding will also tell this.
No, finding will see, but here, sale deed dated one, whereby the purchaser is the monthly tenant for the monthly.
And then they are saying at page 37. Purchaser is the monthly tenant for the last 80 years.
Huh?
At page 37. The last line, where is the purchaser is the monthly tenant for the last 80 years? You want to change the color of the landlord?
Now, after purchase.
Yes.
By the. By the partnership firm. The partnership firm was dissolved.
Yes.
Now, who were there in the partnership firm?
So there, my lord, Mr. Shamlal Agarwal,
Huh?
then Shita Devi,
It's a registered partnership firm.
registered partnership.
Let us see the certificate of registration.
Also, will find page 29. Deed of partnership. It are Bitcoin and Rajasthan.
Mother and son.
So the sale has been made to them.
Yes.
So if the sale has been made to Badridas Pannalal, a partnership firm, who are you?
Now, my lord, that's the reason I want to show this document, valuation list. Platform, it will be very clear. Badridas Pannalal was on RAM under the column occupier. Then it was in 1921. And all these things have been suppressed. By suppressing this thing, my lord, they went on doing partnership business. And then, my lord, this
No,
partnership
you
was
mean to say that the sale deed has been made in the favor of Badridas Pannalal HUF.
my lord, what they are showing the picture that it's not a HUF part. It is, my lord, it's not, proportionate is not there, it is their case. They want to say now it's a partnership business, we went for partnership, then we have dissolved. Now it is, since we have purchased it, it is our property. So in fact, my lord, your lordship can
Then how did you know from 2003 onward?
Lord,
Because there seems to be no explanation out here. Why didn't you challenge this from 2003?
my lord, those are the, my lord, initially I wanted time to get certain
Not
information.
necessarily, we have to see from the plane. Where is your statement out there in the plane? Why on earth you did not challenge this in 2003, 2023? Because isn't there limitation? The question of limitation, because unless you have, you can challenge the sale deed. It should maybe a bar. In fact, regard
That's the reason, my lord, I wanted certain instruction from them.
feel a bit mistake. Take a water wheel.
When the construction will go, the nature and nature will change.
Think about it. Okay, he's given indemnity. He's going to lose everything. You are taking away his right. Construct. If you give him indemnity, that in the circumstance you lose the case.
Lord,
Then you pay.
I should take it the day after tomorrow. Lord, the meantime, I'll take it.
A bank guarantee before the court. 5 lakhs.
For that, my lord, I'll take it.
25 lakhs. This is how much you will earn. We take it every year. 25 lakhs. Give a bank guarantee before the court. That will be renewed till the disposal of the suit. Or he gives undertaking that in the circumstance he loses the case. Where I passed many orders. If he loses the case, without any further decree, he will give you the land. Building. You be happy?
Let me take it, sir.
Or 2 o'clock.
Yes.
Is the matter tomorrow at 2. You go through my judgment I have passed,
Also, I have taken.
but you have to give an undertaking.
Also, I will give an.
If that undertaking of both the persons concerned, that look here, A, that in the circumstance out there, if we lose the case, then without, or the suit is decreed, that without any further decree, you are going to hand over the possession or demolish whichever he wants.
They claim 50% of the land. 8 less us 50%, they are claiming 50% of the share of the land, not the entire land.
You don't give it then still,
I will give lots. If they, I will lose the case, I will hand over to.
exactly as per that.
I will give.
My lord, I will highlight it.
So the moment you give that, the balance of convenience shifts in your favor for not granting any injunction. And without that, other two have no business.
I understand.
That means there is a decision of the office. But they will have to give an undertaking.
This is what I'm saying.
Yes.
Have you seen the judgment? You think 2025, na? See the undertaking I have recorded also. See the undertaking.
Exactly, my lord, that was the thing I wanted to submit before the show. If that undertaking is given, so
Let him give an undertaking with an, we have it on 9th. You give an undertaking exactly like that by filing an affidavit of those. Then we'll change the balance of convenience in your paper. Then I don't think he will have an objection. Because after all, in my opinion, the construction should not be stopped unless it's absolutely grave. Because of the fact that there might be a lot of the litigation may take 10 years, 12 years or 14 years. But then it will come to the high court and what will happen out there. At the end of the day, he is going to lose. Because he must have collected a lot of materials and all. And on the other hand, if you will get it, your only the reason why he should not construct it. If he constructs out there, it will be difficult for you to get a decree for the house. So we'll have it on 9th. This is the matter on 9/5/2025 for further consideration. In the meantime, liberty given to the appellants to file an affidavit, bringing on record their undertaking.
Item 10.
Matrimonial agreement on the ground of mental cruelty, Lordship, divorce was granted to the respondent.
But divorce granted.
Yes, Lordship. Before I start, Lordship, there are some defects in the memo of appeal, Lordship.
Huh?
There are some defects in the memo of appeal, Lordship.
What happened?
In the Lordship, the body of the memo of appeal, we have stated there is an order dated 25/2/2025 as Annexure 6, page 7. Lordship, and impugned judgment as Annexure 7. But wrongly index was typed up to Annexure 6, Lordship. So Annexure 6 was not included with the memo of appeal, Lordship.
Madam, tell me one thing.
Yes,
These,
Lordship.
first of all, these appeals are drawn under what provision?
Lordship. Section 28 of the Hindu Merit.
That is the provision by which you file an appeal. How is an appeal drawn? Isn't it drawn under Order 41 Rule 1? Does it require all these unnecessary things being mentioned? Except the grounds of objection?
I have taken one ground that my section 25 petition was, Lordship, taken to be considered at the time of judgment, but that permanent alimony was not given to the appellant, Lordship. That is one ground, for that I have enclosed all those orders passed.
You have not taken that ground.
Taken.
Then
So I have enclosed the order passed by the London District Judge,
granting you permanent alimony.
not done.
Then
That annexure is missing, Lordship, that was not included with passed by the managed because lordship after the amendment was allowed.
What happened?
See, after amendment was allowed, lordship, and I approached the Honorable Court on when this was issued, lordship was pleased to see what order the landed court below passed, and lordship, the case is fixed for filing of amended WS lordship. Since the lordship, all the issues have been decided, and the suit will again start from initial stage, lordship. And lordship, while filing the amendment petition, lordship, there is no due diligence on the part of the plaintiff, lordship.
Counsel. Be clear,
Well, lordship.
be clear. When you when you file a suit for eviction, ejectment of a tenant, the tenant says that he is not my landlord. The suit takes the color of a title suit from a recovery suit. What he is asking is only that he wants a declaration of his right title interest. What is wrong? There is no requirement for amendment filing anything more. He has to only decide. There's no question. He has already got, you have already given your title document, I suppose, evidence.
I have already submitted the amended. Amended plan has been submitted.
I'm not on that. I'm asking you, have you given your evidence or not?
Already.
You've given
No
your
further
document
evidence.
of title or not?
No, I shall not adduce any further evidence.
Therefore, there is nothing. It is only the prayer which is being said.
Lordship, the entire plaint was sought for amendment, lordship, and initially, lordship is correct that when the defendant has took the plea of adverse possession, but lordship, here,
No, then. Defendant has taken the plea of not of adverse possession. He says that this fellow is not my owner.
yes, lordship.
He's not my landlord. I'm not his tenant. So the moment it becomes you are therefore challenging his title. So as per law, there are many judgments to the effect when the tenant says that he is not his tenant, but he has his independent title, it converts itself into a title suit.
But lordship, the plaintiff has also not this is submitted lordship his ownership.
Not very good. You should be happy. His suit will be dismissed.
Lordship, and
You want to help him.
lordship, but lordship,
You take his undertaking that he is not going to
Reduce
fight,
any
give
further.
evidence. Matter over. On that, let them vote. It is only a relief being sought for, nothing more. His amendment is only saying that seeking a prayer that for his right title interest. That's all.
lordship, but lordship, the entire plain in the plain lordship, for lordship pleases, then the amendment sought by them lordship, the on ground that there is no due diligence lordship, which is to my limited understanding lordship, there is.
Mr. Counsel, this is not a question of due diligence.
And lordship, for if they have sought amendment in the post title as well as in the paragraph lordship. Not
We-
only the relief.
Mr. Counsel,
Lordship,
we don't require, he actually does not require play A, B, C. What he requires is only B. That is his relief. He wants to include the prayer for only the prayer. He wants to make the plain look nice, that's all. Filing of a written statement also does not arise. You yourself have stated that he is not the owner.
Yes.
Yeah. He is not going to give any evidence. The court will hear, this is only the which is being asked, because if he does not ask this, if he is the owner and he does not ask this, then it will have a far-reaching consequences. He will be non-suited.
lordship, for that, lordship will find, we will consider lordship the amendment What Rossi was stated, only that part, only the paragraph will be inserted, others may not be allowed also, because if last order is
What is he asking for? Let us see. Kindly come to page 45. For declaration of
Right.
right title and interest over the suit land means which is there after the word prayer, the plaintiff wants to add the following. For declaration of right title, this is in the cause title. When you mention out there, suit, what is the suit for? On the right hand side, this is one. Then the plaintiff has got right title and interest over the suit land as he is the absolute owner. He has also mentioned this. He wants to conclude it in that word. Because you are saying, because he does not have a right. You are the first one who come up and say that you don't recognize him as the owner, landlord. So therefore, their law is very clear. Now what he wants is, suit is valued at rupees 10,000 for the purpose of jurisdiction and court fee and a dwellerum area at 74C. Let him put this. Take this objection also. He has to pay 22,000 and value of the suit is at 10,000. Let him, he is doing it. And the last line of the amount of AR be replaced by the amount so and so. So you want to amount, give less amount.
Yes. Okay.
Okay, so
You are converting a suit. Now earlier you were the landlord tenant.
Landlord
Tenant. Landlord tenant of a house.
Defendant number 3 is not the tenant. He was inducted by the defendant number 1.
I am saying he was a landlord, it was a
Yes,
landlord
yes,
tenant of a
was
house.
realized
or-
that the
Tenant of
area
the house or the building,
and they
land.
Yeah.
Tenant of the house or the land.
land. Your lordship will see the execute. The lordship will see the.
Tenant of the land.
Yes.
Then. a decree.
Tenant of the house, but the area of page number 19. Area of Bosty Land Weathering.
Let it go. You want to file additional written statement?
Lordship,
You file. He does not want to file additionally. Let it
Lordship,
get delayed.
Lordship, they have already filed the additional amended bail lawsuit, and while swing this lawsuit was pleased to know this was grant us the stay order lawsuit, because lawsuit was in lawsuit phase, what lawsuit, there is no stay lawsuit. While issuing notice, and lawsuit says that lawsuit wants to peruse the order, what learned court below will pass on the next day. And lordship, for a moment, if lordship wishes to see the order passed by the learned court on 5/3/2025 lordship. On which day lordship the case was, on that day lordship, they have not filed the amended claim lordship.
You should be happy this matter has gone to the second day.
On the state of motion also lordship stated that I can stay there for another 10 years lordship, but the fact is lordship, if amendment is allowed lordship, I will be, and lordship, one thing is lordship, the written argument was filed, oral argument was done, and after at the time of judgment lordship, they have come up an amendment sought for an amendment of the suit lordship, and suit is of lordship 2017, and WS.
Who is in occupation of the suit premises?
Especially I am.
You should be
the
happy.
occupation of the suit land.
Let this suit go for another 10 years.
Lordship, it won't be happening lordship.
You only submit that you should be allowed to file your written of additional written statement. Be happy, remain there.
Lordship,
Hello.
but for a moment, lordship, lordship, there is the order passed by the.
Heard Mr.
Then-
So the learned
then-
counsel appearing on behalf of each time,
Lordship,
by the learned counsel appearing on behalf of the respondent.
lordship, may I submit one thing?
Please.
Yeah, then lordship, his submission will be recorded that no further evidence will be laid by them.
Are you going to file additional written statement or not? I'm asking you that.
I'll have to also see again one for a moment also whether.
The moment if you file additional written statement, in fact, you don't require, you have denied his title, absolute, you have title is declared. He has already given. I don't think you should do anything. What you let him do, let him prove it. I'll record he's not going to give any evidence matter. Heard Mr. So-and-so, the counsel appearing on the and Mr. P. Upadhyay, the counsel appearing on behalf of the respondent. Is an application filed by invoking the supervisory jurisdiction of the court under Article 227 of the Constitution, challenging the order dated 19/2/2025, passed in Mizi case number 78 of the 2024, whereby the learned trial court, whereby the learned court of the civil judge junior division number 1, where?
It is at page 56. Operative part,
Division number 1, Nalbari. Division number 1, Nalbari, had allowed the application seeking amendment of the claim with a cost of rupees 8,000. The learned counsel appearing on behalf of the petitioner had submitted that the instant application that the learned trial court did not, that the learned court of the civil judge junior division number 1, hereinafter referred to as the learned trial court, did not take into consideration that the said application, that the petitioner here, the plaintiffs did not have exercised due diligence. And as such, the impugn order is required to be interfered with. Mr. P. Upadhyay, the counsel appearing on behalf of the plaintiff, appearing on behalf of the respondent, who is the plaintiff in the suit, submitted that in pursuant to the order dated 19/2/2025, the amended plaint has already been filed. And he further submitted that what is intended by way of the amendment is insertion of the relief seeking declaration of right, title, and interest, which arose in view of the filing of the written statement by the defendant oblique the petitioner to the effect that he is not the tenant of the petitioner, of the plaintiff. He further submitted that the plaintiff had already adduced this evidence and could not adduce any further evidence. This court had duly taken note of the application seeking amendment of the plaint and the amendments which have been sought for, as is mentioned in paragraph number 5 of the said application. The amendments which have been sought for is essentially to include the prayer, the relief for declaration of right, title, and interest over the suit land, and nothing more. This court have also perused the impugn order dated 19/2/2025 passed by the learned trial court. And the reasons so assigned by the learned trial court, in the opinion of this court, appears to be in consonance with law. Further to that, this court takes note of the judgment of the Supreme Court in the case of wherein the Supreme Court categorically observed that on account of negligence, inadvertence, and mistakes, the reliefs of amendment ought not to be deprived. That view of the matter. This court finds no ground to interfere with the order dated 19/2/2025, passed in media case number 78 of 2024, arising out of title suit number 56 of 2017 by the Court of the Learned Civics and Junior Division number 1. There's no state, huh? No state.
Lordship, one submission may record, Lordship, they have not filed the emanated within time as granted by the order, Lordship, by the order.
Has the court accepted it?
Because Lordship, there is no stay, Lordship, so
The
Lordship.
court has accepted
I
it,
have been
I can't
deprived.
help it. You see order 16, rule 18,
Lordship, if so advised, Lordship, the defendant will be allowed to file his.
then I can't stop him from giving evidence. Then it will have far-reaching consequences. Do you want to give evidence?
The evidence was already filed by both the parties, Lordship. It was.
Should be happy with that.
Lordship, and Lordship, there is, apparently there is no due diligence at all, Lordship, and the Lordship, the plaintiffs is,
Varun
I don't know
Pawar.
why. I don't know why, Lordship, but they are only dealing the matter, Lordship, despite of not having the position, Lordship.
You should be happy.
Lordship, but I am also not getting the title of the land, Lordship. That is the difficulty because of the
Have
pendency.
you filed a counterclaim? You have filed counterclaim? No. Then tell you what.
The last of the project asks about the whether search sheet is filed or not, Lordship. But maybe instead some no search sheet have been filed, Lordship.
Huh?
Whether search sheet filed or not, Lordship, asks on the last occasion, Lordship. Now I have taken instruction, no search sheet have been filed till today, Lordship.
Charge sheet not filed.
Yes, Lordship.
Then? You have not deduced evidence also.
So we had given Lordships, page 40, Lordship, we have annexed. Lordship, kindly see the judgment, Lordship, page 56 onwards. Page 56, Lordship.
There was an accident.
Yes, Lordship. That was not denied by the insurance or any other.
In 2024 passed by the learned member motor accidents claims tribunal. Yeah. In number 43 of the by the whereby the same claim proceedings was dismissed. Out of the appellant submits that the learned tribunal have failed to apply the law as applicable by appreciation of evidence in motor accidents claims tribunal and rather applied the law as is applicable in criminal proceedings, taking into account the same grounds of affliction, ground of repeat, action that was repeated with
Public. 14.
Wait, please, hold on.
Yes, what is your ground?
Also, here, my lord, the present of the case record number. The deceased was held to be a unauthorized passenger in a goods carrying vehicle.
Huh?
Deceased was held to be a unauthorized passenger in a goods carrying vehicle. Despite that finding, my lord, there is an order for payment and recover the amount from the owner of the vehicle in due course of time.
Then
So, Lordship, for this ground, my lord, I'm relying upon the judgment of our High Court, my lord. May kindly see. There are 35. The 36. 36. Mark.
did the Supreme Court in that judgment say that we are exercising 142
Yes. Yes,
in Vishnu Dutt Sharma?
yes. In all the judgment referred to in this judgment, my lord.
Huh.
The section, the article 142 only, for doing complete justice, that can be done. In respect of unauthorized passenger. Other than the federal defense.
Where is the judgment? Is Swaran Singh? This one judgment, no?
The forensic, is in respect of driving license.
So what? Principle remains the same.
My submission is that, my lord, only in respect of statutory defense, it has been made available to the insurance company under section 149, is here and partly. In that, those defenses, pay and recovery can be ordered under section 149, subsection 4. But this is a defense which is beyond the, it's as good as no policy in respect of that particular person traveling in that vehicle. Liability is not extended to that person.
Your Lordship may kindly see, there are 30. There are 30 of the judgment. I have read it. Lordship may kindly see, there are 30, the judgment I have. read it.
No, I'm not going to see all this. Because the Supreme Court has made it very clear. You have to prepare to pay.
May I read for a moment, may I read?
No, not that judgment. That judgment. Question has gone to a larger bench. Observations so made in Baljeet Singh, Baljeet Kaur has gone to a larger bench. But then also court directed making opinion irrespective of the matter being pending before the bench. This was reprinted and held that the High Court was wrong. And as such directed, because there was a direction given by the High Court saying that he is not entitled to get anything, the direction was only given to the owner. Then thereupon, the Supreme Court said no pay and recovery. Here, the Supreme Court makes it clear that it is not 142,
Under 141.
not 140.
Repair, your food is okay. That will fix for any company. May I please, Bakshi? I'm getting up my prayer again, I made in the morning. Good. The affidavit was filed last week, so I filed a reply to the affidavit.
Third,
RJ does.
RJ does, the learned council submits them. Has some time to file their affidavit in opposition. Affidavit in reply to the affidavit filed by the respondent. I think petitioner, if so advised, will be at liberty to file the reply on or before the next step.
Deeply obliged.
Hearing under order 41 rule 2 CPC, item 18.
This is a second appeal by the plaintiff against the judgment of reversal. Plaintiff has filed a suit for declaration of right title interest and also recovery of first position by evicting the defendants who are the permissive occupiers. In their WS, the defendants have denied our title and took the plea that they have invaded the right. First trial court has passed the decree in our favor by declaring our right title and interest. As also for the eviction, but first appellate court, without any plea of adverse position, decided the issue number 2 against us and decided that the issue of limitation on the point of adverse position. No plea was taken in the WS by the defendant side. And also in issue number 3, the Honorable Appellate Court has refused to appreciate the amiable adopted judgment and said that in spite of we have the recorded Pattadas, which has been admitted by the defendant side to reply to our notice. Say that no, we have failed to prove our title.
The written statement,
Written statement is at page 81 to 89. At page paragraph 4, they have taken page 81 regarding the barred by law of limitation. Simply maintainability, they have raised one that suit is not maintainable without giving any reason why the suit is not maintainable.
What is paragraph number 6 of the claim, that paragraph number 6, page 76?
Yes, sir. We have the recorded Patata since 1972.
That
We
is
have
okay.
requested to vacate them, then we have served a notice in reply. They have admitted that yes, we are the recorded Patatas.
Then,
That's why we have filed the suit.
no, read paragraph 6 of the claim.
That mutation was cancelled, Lord, sir, because we are stranding of the mutation.
I'm not on that. Question is, the evidence on record brings in that in 2002, they tried to get their land mutated in their name.
Yes, Lord.
So isn't it an attempt made by them to show that they are the owners of the land, rightly or wrong?
No, because Lordship is the established law given by our Honorable Guwahati High Court that mayor entering the name and mayor existing the name without any other action will not starting point of the limitation. Lordship, I am relying on the reported judgment of Harindra Chandra Nath and others.
Okay.
Right from Privy Council, Honorable Guwahati High Court has paragraph 12, 13. When in at para 8, the Privy Council has been referred there. Mayor,
No, but you see paragraph number 12, it says the court observed that so long as an adverse entry in the revenue records does not injure the plaintiff, he did not come to the court at all, and hence a plaintiff in a suit for declaration that he is under, and that he is under proprietary is not out of time and he stick the suit to so and so. The suit. Now, here is the case where you say in paragraph number 6 clearly that to your astonishment, he made an attempt that he is going to,
we have filed objection against their name was again cancelled, Lordship, mutation was cancelled. They have not come up with
so
any
you
counterclaim.
mean that they were trying to, on that very day, their possession has become adverse.
No,
Earlier it was
That is
permissive.
the finding of the first appellate court, Lordship.
Right.
And according to us, that is the perverse finding, Lordship.
Why?
Because of this Harindranath judgment and all other judgments followed there. Mayor entry in the mutation, neither it confers title nor it,
No, does not confer any title. There is no quarrel, but he tried to possess.
and
legally
mutation will
rotate
start
his
from
name.
when they will deny our title.
Huh.
They have specifically denied our title when we saw the legal notice on them.
Prior to that, they wanted to get their names mutated from that way, which happened in 2002. You jumped to 2017.
But
Why?
they have not taken away any plea of adverse possession lordship in their WS. No, it is the established principle of law that adverse possession has to be plead and proved. They are totally silent. My starting point of limitation when they have denied my title in reply to my notice. They have to plead, yes, my adverse possession started. Adverse possession has to be taken in the WS. In their WS, they are totally silent regarding. They simply denied my title. They have claimed that they are claiming title through one icon nation, whose name was cancelled. As on today also, their name was not in the patta, recorded Jamabandi, certificate copy of Jamabandi. My limitation will start, lordship, when I have served the notice, they have denied my title, and immediately I have filed the suit.
And what is your claim based on?
My name is recorded, I have a recorded patta since 1972.
Did you
My brother
enter,
is Imran.
did you exhibit the patta?
Yes, Lord.
Patta has been exhibited.
Yes, Lord. Both sides have exhibited the same patta, Lordship.
No patta. No patta.
Patta, sorry, Lordship, Jamabandi.
No, it is no.
Because at Charadev, there was no survey settlement operation. It was
No,
in
no, what is
1972.
exhibit three?
It was action of,
Compare copy of the registered sale deed of so and so executed by municipality in favor of. What
it
is
was
the
Lordship,
name of
annual
the
patta land. In the 72, it was converted to the Yadi patta land. And since then, no patta has been issued. Names are only come through the Jamabandi.
Jamabandi cannot be a grant of IR, you cannot be granted that.
No
Whatever
patta.
adverse possession. On these aspects also, you have not.
This much also, they have
If the
Appellate
if
court
it
has
goes on
raised the
issue
issue,
number
but
3,
in our Honorable High Court in Naviyabala Dutta case, Lordship,
Hmm.
it cannot be simply brushed aside. Long standing records, unless we have examined the bundle also, we have get it verified, yes, our name exists in the Jamabandi since 1972.
This judgment in Omiyabala.toy has been stated in the context of section regulation 41.
Yes, Lord.
Regulation 41 comes in at the stage of settlement of the records. So when the settlement proceedings are started, then there will be certain entries being made. So when these entries are made, there are objections being sought for. When these objections are being sought for, then they pass this order. So and this cannot be a document. But
Because they have also no title to.
forget about them. I'm not concerned with they. I have not filed any counterclaim. You have not proved the document of title.
So no patta has been issued since 1972. Lord.
So what happens to the earlier patta?
It was annual patta.
Annual patta.
Originally, it was annual patta land in 72, it was converted to Yadi patta.
So therefore the patta will be given. Some document will be there. Where is the document? We have not agreed the
May I
document.
don't think it's may I take further instructions, Lordship.
Fantastic. Further, the council supports that sometime may be granted to him obtaining instructions. After when? 21st,
After 4 weeks, Lordship, I have to bring it from Sonari, Lordship.
after 28th of May.
Orders item 19.
Appears on behalf of the appellant when the matter is called. It is seen that the appellant have not appeared before the court on 38/2024, 8/1/2025, and today also none has appeared on behalf of the appellant. It appears therefore that the appellant seems to be not interested in the instance, which the instant appeal stands dismissed for non-prosecution. This year, if any, be returned after 90 days per release.
20. But here in this case, what happened?
We strike out the name
I
of
was
respondent number
directed
1 and
to-
2.
Directed to take the trustee service. I communicated with the party, my lord, what that has returned. He is not found. So, my lord, my humble submission before your lordship, I don't want to continue with this case. Because there is no instruction, the communication is not there. In that case, my lord, if your lordship please, I already pray before your lordship, under order 3, rule 4. That my advocacy will be discontinued.
Why?
My lord, order 3. Order 3, rule 4, my lord, CTC. Like that. It may be determined. They are not communicating with me, matlab letter is returning. Oh, Lordship, would be pleased to see Rule 4,
Not necessary.
Order 3.
Let me dismiss the appeal. Not merits. No case.
I am leaving to your Lordship, but my representation may not be. Because I cannot take the responsibility. I am not decide, arguing the case on bail.
You have given a
My
certificate.
submission may be recorded.
You have given a certificate. You cannot take away yourself.
No, no, my lord, your Lordship,
You have
why
given a
your Lordship
certificate.
directed me to take paper publication service?
The council.
They are not
the
communicating
council,
with
let
me.
Tell you, who is Mr. Mustaqim Rahman? He has
Mustaqim
given
Rahman,
a
yeah, he was my
certificate
junior.
that these are substantial questions of law set forth.
My lord, that is their matter. I am not arguing on substance.
Don't appear, then I'll dismiss for default.
My lord. Yes, that may be. That may be better, not on
I'll
any.
appear on behalf of the Apple and Concord. For the scene that no steps have been taken up. One and two. By the various opportunities being granted. In the above, it appears.
My lord, my submission may be recorded, my lord. Otherwise, my lord, again, that I will be in fault, my lord. The dismiss for default. I am present before your lordship. I am present before your lordship. So my submission may be recorded that I am not continuing with the case because I am handicapped. They are not corresponding with me. They are not replying my letter. They are not found in the letter place. So, my lord, I am praying before your lordship.
When did you inform them?
My lord, yes, I sent the letter, my lord, that is.
Where is that letter?
My lord, letter is not available.
No, you file an affidavit. Bring on record that letter by which you have.
I wrote letter and that has been returned.
Bring it on the way of an affidavit. Then I will terminate your ER that when you have informed them, then I'll terminate and finish it all. Otherwise, this has no case, no merits. Unnecessary.
No merit, my lord, on my presence, my lord, it is decided, my lord. I'm not going to argue. Because, my lord, I have been given.
Whether the
stamp to
suit has been
publish
dismissed.
notice.
Suit has been dismissed.
It was dismissed, it is restored again, ma'am.
No, was the suit has been dismissed. So till 2022, they were very much there. They had connection with you. That again on the MSA Column Council appealing on behalf of the applicant that he has no application with the applicant.
One applicant.
Really?
Only applicant. He was defendant number two.
In spite of appellant about right, he further submits that he had duty to the appellant that he wants to withdraw his.
Number that I have not withdrawn, I have not informed that I want to withdraw. I
Then
sent,
why you are not informing that?
no, that I sent to him that court order to publish notice.
No, you cannot. You have to argue then. You argue,
No, my lord,
you argue now.
your lordship,
No, argue on the merits. You are still there. You have not stated that. No case.
no, my lord, your lordship directed me.
Absolutely no, Mr.
Well, let-
Mr.
let-
Mufet,
let me
the
complete
question
my-
does not
let me
arise
complete my-
unless you,
let me complete my
unless you
position.
say that you want to terminate and inform him. That is why I'm asking you to file an affidavit.
No,
You just one day
no,
cannot
no,
say,
madam.
I withdraw, no.
Let me place my case. My position is this, my lord. Your lordship directed me to publish notice in paper. If your lordship want to decide the case without publication of notice against the respondent, in that case, my lord, I can argue.
Argue,
If your lordship,
argue,
without.
argue,
without
argue.
notice of-
You argue, no,
In that case, my lord, I want 2 days time or one day,
argue.
tomorrow,
There
day
is
after tomorrow.
substantial question of law.
Well,
There is
day
no
after tomorrow, in that case. Day after tomorrow, my lord, I am on this,
No,
that I am unable to publish notice.
no, if you don't publish notice, why haven't you been able to serve it? I don't find any good grounds.
Then in that case, my lord, tomorrow or day after tomorrow, my lord, I am not prepared today.
Why do you
On
need
that
it?
point.
Why do you need the respond number two? You only take against respond number one, the plaintiff. Why are you taking the respond number two?
He is pro forma respondent.
Why do we require the performer respondent?
Respondent, we are to take notice on both the respondent.
We are not concerned. He is in with the performer respondent, the co-defendant. He's a co-defendant.
It is to be looked into. I am not prepared to answer today,
You have the memo of appeal.
my lord. Yes, memo, okay, no.
And in the memo of appeal, it is clearly seen, the plain, he is a co-defendant.
Pro forma.
No, the defendant number two.
Then I am to see the plain.
Only see, defendant, page 20.
Yes, 20, yes,
Ah,
yes.
defendant number one is Abdul Razak Kodani
Abdul Razak Pradhan, yes.
and defendant number two is you. Isn't it? Page 20.
Yes,
Then,
Munbar Rahman Pradhan.
so why you were fighting against your co-defendant? I এখন দেখুন কোন ভেকেট করেছি নয় এইগুলো আছে I 2009 এখন আই থাকিব stay home. This is an executable in 50. I have the school for how to do my. So I'm telling you.
There is nothing else.
It is seen from the records that by an order dated 19/7/2024, this court made it very clear that as the appeal has been pending since 2009, the appellant was directed to publish the notice upon the respondent number 1 and 2 in local newspaper, and the steps were required to be taken in the month of September 2024. It was also observed that if the appellant fails to take steps for service of notice upon the respondent number 1 and 2, appropriate orders will be passed. So, when the matter was again listed on 21/10/2024, such steps was not taken as directed by this court by the order dated 19/7/2024. The matter has come up after 7 months thereafter, after 6 months thereafter. Then also, the appellant have not taken the steps. From the above, it appears that the appellant is not interested in pursuing with the instant appeal, inasmuch as an appeal pending since 2009, no steps have been taken upon the plaintiff, who is the respondent number 1. Considering the above, the instant appeal stands dismissed for non-prosecution.
But here one thing, my lord, 2022, my lord, appeal was
Mr. Sheikh goes Supreme Court.
my lord, regarding pendency, my lord, in 2002, it was restored.
Not necessary. Who's for non-prosecution? Like 1 steps. Now he will realize the LC will be returned within 90 days. Now he will realize once you dismiss it, then he will come again. I'm not dismissed on merit, he will come. Once you inform him, he will jump in.
My lord.
21. And this is the law. Please, pilot, directly to substitute pilot, the respondent number 1 pilot is the main party pilot in this case. Yeah, in this case, after the last order, my lord, earlier also we said, my lord, letter, my lord. Then again, we have sent another letter, and track report is also there, my lord. That is on 5/2/2025, my lord. We have sent this letter, my lord, requesting the contact us, but they, I think the item is also delivered, my lord. Earlier also, they did not contact me. This time also, they did not contact. Plaintiff, my party, my lord, I mean the.
Who died?
My lord, the respondent number 1, man. He is the main.
Huh?
Respondent number 1.
Respondent number
Tabela.
1.
In my earlier notice, which letter I sent to them, I have stated, my lord.
How did you know that a respondent number 1 died?
My lord, when the matter, when initially was heard, my lord, then we had a telephonic talk with him. One telephone number is there, one Kamjul. His number is there in the file, my lord. They immediately contacted. They informed, my lord, that the respondent number 1 expert
When?
will come and will in 2020 sometime. And they said they will come. His phone number is here, my lord. Since then, my lord, when we said, my lord, you come with their name, my lord, so then since then they are not showing any interest, my lord. This 2 letter, my lord, I have sent 1 letter earlier, I said, my lord, before the matter was discussed, before your lordship, my lord, 21/3/2024, my lord. That was also track report we have collected. It was delivered by.
Wait. You are who?
I am the appellant,
You are the plaintiff.
my lord. My lord, I am the plaintiff.
You are the plaintiff.
Yes, my initial suit was decreed by law. Then appeal by law.
Initially, suit was decreed.
Then it
Then
was
the appeal was preferred by whom?
prepared by the respondent body.
Huh?
That was dismissed against that we take.
You are Muhammad Ahmed Ali.
My lord,
And who was the appellant? Kaporali.
Yes, my lord, Soberali. Soberali is the main, my lord, actually, 99% of the land is in his possession. So far as the other, when the last time they talked to us, they said, when we told him, my lord, the other respondents are there, my lord, we can proceed with them if you don't come. They said, no, all the land are in his possession. This is response number one.
That is why he filed the appeal. Counterclaim also dismissed.
Yes, my lord, yes.
It is seen, Mr. H. Chaudhary, the learned counsel appearing on behalf of the appellant submits that the respondent number one, who is actually, who was actually in possession over the suit land,
Yes,
and for recovery of which the instant the suit was filed by the appellant had expired sometime in the year 2020. It is also seen that by an order dated 21/1/2025, you also see that this aspect have been brought to the notice of this court. In the order dated 16/11/2023. Taking into account that even after opportunities being granted, no steps have been taken from the instant abates insofar as the respondent number one herein. However, it is also to be taken note of that as the respondent number one, as well as his legal representatives are actually in possession as submitted by Mr. H. Chaudhary, the instant appeal abates as a whole, for which the instant appeal stands closed.
problem.
Then the LCR of the case.
To letter, my lord, that is on the, to them, my lord, that is received by them.
Right.
Track reports shows that they've been delivered.
That line लिखी रही वो Mr. H. Chaudhary report कोई देखो Mr. H. Chaudhary further submits that he had duly intimated the plaintiff, the appellant, to take steps, instructed the appellant to take steps. And in that regard, communications were sent on.
Communication was sent on, 21/3/24 and 5/2/25.
5/2/25. But but the appellants have not reverted back. He further submits that these documents were duly received by the appellant, as it would be apparent from the postal track information. During the course of the hearing, he submitted copies of the said letters, which are kept on record and marked with the letter X and Y. I'll prefer between.
Well, and
22. Yes.
I heard this case was lordship, the appellant has taken out the file, lordship I may be allowed to file affidavit that may give some
Mr.
time.
K. Movinder, the council submits that the file have been taken over by the appellant. Appellants
Appellant.
on
Lordship, long back, Lordship. I will file affidavit.
Long
Lordship, I
back.
Try to protect with them, Lordship, in some time, Lordship. I have.
and he therefore submits that
Other side also.
that you would like to bring on record the said statement by way of an affidavit. If we count the above, the list this matter again on 19th of May 2025. File the affidavit. In the meantime, the affidavit will be filed by the council.
23.
Dated second of May, lordship, service not completed upon respondent number 1 and 2.
Huh?
Service not completed. Service not complete.
Service not complete, obviously. This happened in 2022. You seem to be not interested.
Who's taken, lordship?
Whether the learned appellate court dismissed the preventive appeal in a suit for specified by misconstruing the provision of 12. Okay. You taken steps. Upon the newly impleted respondents.
I'm the press system.
Dusty. Where you go? Not far off. Both of you stay nearby. Huh? Same village. Then why you're not taking steps?
It was taken, lordship.
It's the matter again on 16th of June 2025. In the meantime, the appellants herein are directed to take steps upon the respondent numbers 1.1, 1.2, 1.3, 2.1, 2.2, 2.3, 2.4, and 2.5 by Dusty routed through the registry of this court and file an affidavit of service on or before the next date.
24.
Operational dated 1/2025. That the records of title equipment has not been received.
Title appeal not received. But the suit record is there.
Possibly there, my lord, title,
Suit record is there.
possibly title notice records may not be required if the evidence and other exhibits are met.
Has that suit record has the I'll go to record.
Here. Earlier, my lord, it is reflects that title sheet records that has been received. Office note dated 23/1/2025.
Uh-huh. LCR of 1 of 2007 is here. We don't require the whether certified copy of the sale deed is a public document. For this question of law, it is not required. Taking into account the substantial question of law so formulated and the fact that the LCR of title suit number 1/2007 is available, comma, it is the opinion of this court, taking into account the communication issued by the district and session judge Borpeta, dated 29/4/2025, that the instant appeal can be disposed of without the records of title appeal number 12/2008. Puस्तक. Accordingly, this appeal for hearing in the usual course, list liberty given to both the parties to file applications for early hearing.
25.
Here I call the respondent matter. If the record has been handed back to.
Huh?
Record has been handed back because when it can be that it was this particular.
You are justifying. Yeah, in this case, the sale deed by which title have been admitted, title has been transferred. Declared, huh?
The word of the.
Plaintiff. Title has been declared. Now, this is declaration of the title in favor of the plaintiff under, in with, as per which deed? There's a sale deed that has been exhibited. So they are saying that the predecessor in interest sale deed has not been exhibited. So therefore, the nucleus have not been shown. Now, have they challenged the sale deed? Sale deed have not been challenged. Mr. N. Hawk appears on behalf of the respondents. However, none appears on behalf of the appellant. List this matter for hearing 5/2025 at 2 p.m.
26. This case, my lord, I have been provided with some agreement between the parties regarding an amicable settlement.
Huh?
Amicable settlement. They already entered into an agreement and matter was settled amicably. Oh my lord, I want to bring on record by filing an.
You have an amicable settlement?
Yes, my lord, I have also confirmed the matter from Abdul Sattar. He said that, my lord, client approached him and he suggested the client to approach me. So the matter may be, my lord, appropriate application will be filed.
This is a matter of 2016.
Right,
Service is complete.
yes, yes. They appeared for Abdul Sattar.
Service being complete with this matter on 2nd of June 2025 for admission.
But in the meantime, when the matter was settled, I will make an application.
Do whatever you feel like.
27. Interim order, my lord, there is interim.
No interim order. Last order, there is no interim order. Interim order passed earlier shall continue till then. What is the interim order?
My lord, execution case was suspended.
My goodness. This was stayed in 2016. You have it earlier on 26th of May. 26 May.
I will take an
Interim order passed earlier shall continue till then. Yes, what is this? Appeal is admitted. Call for the report.
Under order 43/1R, against grant of injunction. For office number 25/4/2025, service in respect of the respondent number 225 is not complete.
Huh?
Respondent number 1 and 2 have appeared to KPH matter.
Service complete.
Service is not complete. It's not complete.
You don't have urgency.
Already injunction is there in their favor. Injunction is there in their favor.
So why should we dismiss it?
Only for the. This is, I know,
Dismiss it? What do you say? What is this type of, what is page 76?
maybe during my,
Historic. What is page 76?
Yeah, Xerox.
Huh?
At the time of doing Xerox, my
So? How is it possible? On this ground, we should dismiss it. Isn't it?
Madam, the case is very simple, madam.
Very
I, the
simple,
landlord,
therefore I
they are the
should.
tenant, madam. I want to construct a building over my own plot of land, they are responding.
Obviously, rightly done, and that too, you have not given the entire thing. This case, Roman properties,
Hotel lands,
huh?
hotel lands.
They have taken an injunction.
That's all.
There's one councillor who keeps on appearing for Roman properties. What is his name? Keeps on appearing everywhere.
I can see that. I can see that.
Ah, AK Srivas. Where's the impugned order?
Impugned order, my lord will find it page number 87.
Why didn't you appear?
My lord, to the reasons based known to my advocate matter, I am engaged in advocate. He did not appear, neither filed the written objection in the injunction application.
What is wrong?
But my only point is that, my lord, the agreement for tenancy that was determined way back in the year 2021,
Agreement for?
tenancy.
Ah.
And now the tenancy has expired. And the tenancy being the very nature of tenancy being determinable in nature, it is given by section 14C of the specific limit act. So, my lord, that will be covered by, again, my lord, section 41E of the specific limit act. That contexts which are not enforceable and which are determinable in nature, no injunction can be done. So, in spite of that, my lord, the court has not considered that aspect of the matter and has granted injunction in their favor.
Who is to construct?
I am the master, that all.
You have entered into an agreement with whom?
I thought the respondent number 1 and 2, who are the tenants, right?
For what?
Way back in the year 1987, tenancy agreement was entered, my lord. They had
What agreement?
tenancy agreement.
Ah.
Expect, my lord, of a building, my lord, which they will construct. They will take 8,000 square feet out of the same building, consisting of G+4 stories, my lord.
They are to construct. Tenant is to construct.
That is their bidding, my lord.
No, I am asking you. You are the appellant.
Right.
So you entered into an agreement with them, thereby allowing them to construct.
Right.
Then
They constructed the G+4 building and tenancy continued. And sometime in the year 2000 and in the year 1990s, the original landlord they expired. Thereafter, they did not enter into new agreements, but the rent was enhanced from time to time. In the year 31/12/2021, the tenancy determined.
Hmm?
The tenancy expired. Right? And thereafter, they did not renew the tenancy. Now, my lord, we wanted to construct over the fourth floor, another floor. Right? Their contention is that if we are allowed to construct over the fourth floor, that would, my lord, they lose their ambience because they have a lobby in the fourth floor. So that would make their aesthetics look very bad. The building would become weakened, but there is no report of any GMB or GMC or any engineer to that effect. That if I am allowed to construct, the building would become.
you got a permission.
Till there I have not.
Then what is this? You have
But,
not
my lord,
taken,
if I
you
do
have not taken.
permission, my lord, that civil court is not the right forum. They should approach the GMB or GMC.
I'm asking you, have you got the permission?
Yeah.
How can you construct? Hello, we have it after 6 months,
After
6 months.
vacation.
It is seen that service upon all the respondents are not complete.
My lord,
Taking into account the above, it's the matter of the completion of service.
okay. 28.
Corrected the address of restaurant number 51.57 lordship. They maybe issued notice lordship. 5.1, 5.2 and 5.3.
This was not sufficient.
Thereafter,
It has
lordship,
been
we have
submitted by Ms. Chaudhary.
we have already
counsel
corrected.
appearing on behalf of the appellants that the newly, that the address of respondent number 5.1, 5.2 and 5.3 have been duly corrected. And therefore, she requests, submits that steps be needed to be taken against the said newly on a substituted respondent. Taking into account the above, I issue notice upon the refresh notice upon the respondent number 5.1, 5.2, and 5.3 by way of registered as usual.
Publish.
29.
Yes, who wants to go from where?
Yes, sir. I am petitioner wife, but I make a case in Hojai Lordship, the judicial separation. So, and I filed 2 cases in Bongaigaon where he is appearing. Husband is appearing in my place, Bongaigaon. Husband is, respondent is appearing in 2 cases in Bongaigaon. And he filed 1 case.
Should not be allowed, my lord. Their ground is that she is financially constrained to come to Buzai, my lord. It is totally false, my lord. She belongs to a very rich family. She has a beauty parlor of her own, my lord. Totally false, my lord. The petition is based on totally false.
I explained in paragraph Lordship, what are my problem?
I have already
Lady of-
stated everything in my affidavit, my lord.
What they have taken stand is separate. In 2 cases, he is appearing from coming Hojai to Bongaigaon. And it is a same matter, he can appear also, Lordship. And a lady of 32, how I can go? My parents are in getting position, Lordship. That's my concern.
Already, my lord, she has 5 cases after cases, and
That
for
is not the
which,
issue,
my
but-
lord, the respondents, younger, whole family was involved in every cases, my lord, and for which they have to lose one child, my lord, during this journey, my lord. I have already annexed, my lord, death certificate also, a 7-month-old baby, my lord. Implicated whole family, my lord. And of her own, she left the house, my lord. It
That
is
is
not
but-
that she has been driven out,
That
my
is
lord.
not-
You
It is
don't have a
about-
beauty parlor?
Yes,
no,
my lord.
Lordship.
No, no, I have said that, my lord.
That-
I have already
you-
stated, my lord.
File your reply
Yes, sir.
as to whether you have a beauty parlor.
Yes, sir. Yes.
Others are business
I will
also,
ask-
she is running her father's business also, my lord. They have no, my lord, son. That is why she is boxing all the time to take the respondent to her house as for join, my lord.
And here,
3-4 times, my lord, she has attempted suicide, my lord, and is wife, my lord. She was saved by his family member, my lord,
who's something?
the respondent's family. That is why he has filed this judicial case for judicial separation. And she is used to, my lord, come to my lord from Bongaigaon to Hojai, my lord, of her own, with her own car, my lord. It is not that she is unknown, she knows nothing, where she will stay. That is not the point, my lord. She has own car, she all used to come, my lord. Earlier, but in the petition, it is stated that where she will stay, she has no money. It is totally false, my lord. She belongs to, my lord, very rich family, and she has got no problem, and the respondent's family is, my lord, the lower middle class family, my lord.
Respondent is a doctor, Lordship.
Doctor.
Respondent
He
is a doctor. I am
my lord. He
unemployed,
is
Lordship.
dentist, my lord.
I am saying I am.
He is at top June, my lord. Six. Okay. Okay.
30.
They're paying for?
Respondent number 3, 4, and 5.
What about 1 and 2?
One expired on 10/2008.
And 2?
2 Lordship, which actually is my brother, but he's living.
1 expired.
If we have handed over the brief, the residential premises, I have submitted one application informing everything, the registrar judicial, that we have handed over to the brief.
Five and 2.
I have not filed, I have filed this. Your lordship permits, I will file them. Informing that withdrawal of our Balatnama.
Have you intimated them?
Yes, by the letter
Have
and
they received it?
Yes. Tracking is there on the back
Now
side.
appear from Ms. Eltas Gupta, the Union Council submits that by the communication dated 28/4/2025, the respondent, the petitioner have been duly informed. By the communication dated
20,
25/1/2025. No. What is the date? 5/2/2025. The petitioner have been informed that the file. Who is Mukut Fupan?
the petitioner, your lord. Okay. Plaintiff petitioner.
By the communication 25/1/2025. The file of the records of the instant case was handed over on around 5:30 PM. And in that regard, have also enclosed the postal receipts, which evidences that on 6/2/2025, have received the same document. Considering the above, petitioner thereupon have not engaged any person in the instant proceedings. Bench of Justice, this court fixes this matter again on 6th of May 2025. However, vacates the interim order passed on 28/4/2023, whereby title suit number 11, pending before the court of the learned civil judge number 1, Kamrup Metro, was stayed. Judge number 1, Kamrup Metro shall proceed with the application of title suit number 28 of the 2011 in accordance with law. Shall place a copy of this order before Alcourt. Fine.
Katiwa,
Strike out. Perform respondent 5/18. Strike out. You have not taken steps.
yes, sir, I pray for his side.
So and so the learned counsel appearing on behalf of the appellant submits that the names of the performer respond number 5/18 be struck off. So taking into account the above, the names of the performer respondent for 5/18 is struck off. So the counsel appearing on behalf of the appellant shall file a fresh memo parties before the registry of this court, and the registry shall, on the basis of the instant order as well as the fresh memo parties, shall make necessary amendment to the cause title and also update in the CIS. It is seen that the LCR have been received accordingly, which they during was liberty given to both the parties to file application for early hearing.
The hearing, early hearing.
He gave you file an application for early hearing.
candidate subsequent question of law, those are not a subsequent question of law. You know, lots of candidates is subsequent question of law. What then, those are the subsequent questions.
Done. He has 2009 method.
32.
Service complete. Records received. Service being complete and the records having been received, it's the matter for hearing in the usual cost liberty parties for filing an application or filing application for early hearing.
Lordship, we then filed our Wakalatnama, but for respondent number one, we have instructions to appear, but have not received the Wakalatnama.
I need.
33.
If service not completed. Service not completed.
Service complete.
No, not completed.
Service being not complete leaves the matter. What is the CRP business?
My suit has been dismissed for want of evidence. Both the parties have did not produce evidence. There is
Section 6.
a lawsuit. My suit has been dismissed on the ground of want of evidence. But I did not file evidence. The other side also did not file evidence. The other trial court dismissed my suit for want of evidence. That is the case.
Then what case you?
Service will be completed. Service may be completed.
Why? Then why did you file the district court even? No, this type of. Who has been dismissed, so
Impugn order is page 40 law. At page 60 law.
Page?
60.
he did not give evidence. Page 60.
60. 60.
What do you mean? What can the court do? Now, I'll make the people further learn it down. Application filed under section 150. Challenging the 9/11/2000. Where the suit of the plaintiff, petitioner who is the plaintiff, title suit number 7 of the 2002 was dismissed by the court of the learned civil judge junior division number 1 in Sukia. The ground on which the suit was dismissed is that the plaintiff have not adduced any evidence. This court duly takes note that pleadings are not proof. And there is also, and nothing could be shown that the defendants have admitted in their pleadings the case of the plaintiff. Considering the above, this court finds no error in exercise of jurisdiction by the learned court of the State's Junior Division number 1. It's order dated 9/11/2023, which the instant petition stands dismissed for non-prosecution, dismissed.
34.
Going to go where?
From Guwahati to Page.
With Guwahati.
Guwahati Kapu question.
My husband is where?
Why from Guwahati to Page 4 husband is from Guwahati?
Husband is in Guwahati. Wife is in Tezpur. What does the wife do?
The professor. He's a professor.
Professor of?
Assistant professor in Tezpur University.
Do?
This matter can be not sent to court because there are other 2 cases pending there. So it can be not, I am giving the consent, not it can.
You have not filed your written statement. You only did in district judge Sunitpur, na? Sunitpur. Filed your written statement. On 23rd of June, fixing it before the district judge Sunitpur. Okay? Give your name. Hello.
35.
And Lordship, notice was issued, Lordship, on 18/6/24, but as per Lajna Court order, Lordship,
The respondent cannot, not accept the lordship.
Service is complete.
Not for the lordship. Lordship, it may be
Everything
to serve lordship.
is the appeal for hearing after full.
Lordship, respondent refused to accept lordship.
No, why you are saying that notice have not been served?
Lordship, they refused to accept.
So what do you mean by refuse to accept? Have you seen the CPC? What happens when a person refuses to accept? When there's a elder member in the family? Read the CPC. Is this matter again on 1st of May 2025? And the council appearing on behalf of the appellant shall apprise this court as to whether the service can be completed upon the respondents in view of the provisions of Order 5.
36.
Service being complete, it's the matter for admission on 2025. Contain or is there? Contain or the possibility should complete.
37.
While this matter has been wrongly listed for the draft work, very under order.
No, question of law frame.
Without correct.
It is seen that the instant matter is an appeal, seen that the instant appeal is an appeal under section 100 of the Code of Civil Procedure. And as such, without framing a substantial question of formulating a substantial question of law, this court would not have the jurisdiction to considering the above, the registry directed is the instant appeal to the state of within of the
And the candidate said, service will also complete.
But
Service or
case of me. There's still
38.
His name is right. And for
has the appeal been admitted?
notice has been
If you are our
given 9th of June.
Huh?
9th of June, same 9th of June,
why?
next date. The date.
Huh?
The date, next date.
Why?
Another matter is that.
I'm not concerned with the also appeal matter. First, we have to bring it in the substantial question of law. All right, 28th of May. I have same order day.
39.
Service complete.
As per office note, that is 4 to 25 million. Service upon the respondent will be completed due to the address. But I will be allowed to take her by the, by the service.
I will be.
4 to 25.
What is this matter?
Department is regarding maintenance, because this husband, time for the husband, my lord, he has been paying under section 125 CRPC, that is 8,000. Now she has filed another, this case, my lord, under section 24 of the Hindu Marriage Act. And this honorable court has allowed to pay 10,000 and 20,000 as my lord.
10,000.
Yes, my lord. Now, he's only constable.
The council appearing on behalf of the petitioner. It's that he may be permitted to take steps by way of dusty, rooted through the registry of the spot and file and dusty, taking into account the 4th of June 2025. It's to be taken upon the sole respondent by way of dusty, rooted through the registry of the spot and file an affidavit of service on or before the next public.
40,
Service complete. Service being complete is the matter for admission on
Lordship, may I pray after 21st of May because I'll be out of state.
for admission on 26th of May. 26th of May.
41,
Same order is there. What is this? I have business.
found filed by us for injunction.
You file objection.
Yes, take a final.
One I have filed by me, my lord, where the alternative relief was granted to them by the appellate court. So I want to report it to my.
Oh, that one.
Yes, yes, yes.
Yes, yes, we'll have this thing. This is here matter, no? 24 lakhs.
Yes, 24 lakhs.
I said about order 20, 13. I said about order 20.
Yeah, order.
Order 24. Okay. They were given this amount. Okay. We have this 41 on, let us have it on 3rd of June. 3rd of June. We will try to dispose of at 2 p.m. Question frame? This matter on 3rd of June 2025
I don't know.
at 2 p.m.
They remind them.
Pusto. The registry shall, Pusto, the said appeal shall be taken up for final disposal. Pusto. The registry shall ensure that the records are available. That all shall ensure that the records of the learned the records of both the trial court and first appellate court are available on the next. 24 is what?
My lord, today it was for consideration of stay order. But the lordship. Because the.
Lordship, we have filed a,
You are represented?
yes. Okay. We filed a affidavit in opposition of that. It take
44, taking into account that the service is complete, this matter of 16th of May 2020.
My lord, the first, the court actually is pending on, it's fixed on 9th.
For what?
Very. Actually, this is a, I have filed this CRP against the review petition. Whereby my additional evidence, prayer for additional evidence was rejected. The first appeal is pending for final.
On which date the
On-
matter would be taken up for final disposal. We show this order before the learned court. You will understand.
45,
Which date this in attempt to dispose of the instant damage.
45,
Service may be available upon the response.
We have not taken steps. A notice has been issued, huh?
As per official report 3424.
This, the service is awaited. It's the after issue of service.
40C,
Lordship, as per office note dated 2/5, the answer notice has not been received back. It was sent on 5/4.
Service is awaited. This is the matter of the completion of service.
57, 57,
Matter again on May 2025.